Great, thank you. Good evening, welcome.
Hi. Just two issues.
If you just give us your name and address, please, for the
Colleen
record.
DeMarks, 50 Yellow Brick Road. The first one is, I was talking to the traffic officer, and I'm trying to get the signs for no air braking on Yellow Brick Road.
Okay,
There are more trucks on Yellow Brick Road than I bet in any other place.
Sure.
And he said, no, they won't do it. And he was going to check with his supervisor. No, they won't do it. He said there are enough signs in the township. So I drove around, and most of the trucks come either off 33 or they come down 195, Georgia Tavern, West Farms. There are no signs saying it's against the law to use air brakes. And every morning I hear them. They start braking by my house and stop by the pipe factory. So I'd ask you to please see if we can get two signs, one on each end of Yellow Brook at least, and perhaps some on Georgia Tavern and West Farms to protect these people.
don't we have an ordinance?
We do
that,
have an ordinance, yeah.
Yeah, okay.
But
Have
there's
you
no
ever had
signs,
a-
you know,
have you ever had an
downtown,
opportunity
you
to
know.
maybe get the name of one of the trucks, a license plate, when they drive by, ABC Fuel Company or something?
Oh, I mean, every one of George Harms, every one of Central Concrete, every one of Kerr's, I mean, they all anchor, they all do it. I work all day. I mean, I can get out there at 7 o'clock if you
Sure.
want to get your license plate number, but, I mean, they know, the police know it's a problem.
Yep.
I think he lives on Colts Neck Road. He knows what it's like.
Okay.
They just said it was, they wouldn't do
You have a
it.
comment, Mrs. Schumacher?
Yeah, Mr. Chernisky, we do have an ordinance on that. And every neighbor, every police officer knows the route that those trucks take. And those roads, including that Yellow Brook Road, should be covered with those signs with the ordinance stating underneath of it. The mere fact that somebody says that we don't have enough signs is ludicrous when it's like a bike path, you know, the exact road that those trucks go down. And those roads should be covered with those signs stating that ordinance in our community.
The other comment, we know who the businesses are on Yellowbrook. Could we potentially send a letter from the manager's office to these companies, just as a friendly reminder with a photocopy of the ordinance, just asking that they be friendly neighbors and that they comply?
Correct. Definitely can do
Okay?
that.
So we'll look into both those?
Yep.
Thank
Great.
you.
What else, Mr.
And one
Marks?
other thing, Central Concrete was there years ago, and when they came into the area, everybody was opposed to it because they said it wasn't enough property for what they wanted. And one of the requirements was that they had a detention pond, and the detention pond took up about 25% of their property. Well, been here 3 years ago trying to get this fixed. They filled in their detention pond. There's one little hole there, and it's the headwaters of a stream, so they're always going to be water there. And I don't think just because they've grown that they have the right to fill in the detention pond. It caused horrible
Sure.
flooding, it backs up George Harms, it floods the road, and I just want
Hold on one
somebody to make them put the detention pond that they said they would, the correct size.
You have a question, Mrs. Shoemaker?
If I can direct this to Mr. Nunziato. Mr. Nunziato, do we not have this conversation with Central Concrete not too long ago on this exact issue?
I have taken notes, and I do want to research it before I comment any further, because we did have some discussions in the past, yes.
Yeah, I would like to have an update on those notes, because I'm fairly certain that we've had this conversation.
Which is the one that's causing the flooding on the Girl Scouts property?
That's
Anchor.
That's
Anchor
Anchor.
Concrete.
That's Anchor.
That's Anchor's.
All right, so you're going to investigate this particular issue. Mr. Marks, if you wouldn't mind, if you would give the manager, or maybe just put your telephone number, I'm going to pass this back up to you so we can get in contact with you, please.
All right,
Okay?
thank you. That's all, thank you
All
very
right,
much.
terrific, thank you. All right, the next person, I think the last person for the regular open session, I'm going to mispronounce your name, I apologize.
Ken Chow.
Ken Shao or Show? I'm sorry if I mispronounced it. Good evening, welcome, sir. Says you want to talk about 9B37?
Yes, I do.
Okay. If you just give us your name and address, please, for
My
the
name is Ken
record.
Scow, 14
Scow.
Cherry Van Drive. I want to talk about 9B37.
Sure.
Award the contract of 4 '07 Jeep Liberty 4-door sports 4-wheel drive vehicles. Okay. So, first of all, I want to know who these vehicles are for.
Sure. Mr. Chansky, would you,
Yes, they are for the,
Mr. Chansky, I don't know if they can hear you in the back, I'm sorry.
I'm sorry, they are for the engineering department, the tax assessor, construction official, and land use officer, two of which the vehicles are now off the road and are inoperable. So, and the other two will be circulated. Auctioned. And these are being bought off the state contract.
Okay,
Okay, so we were replacing 4 vehicles is actually what we're doing.
that's correct.
Okay, because it doesn't say that over there. All it's saying was we're purchasing 4 vehicles, so I thought we're just buying 4 vehicles just to have 4 on spare.
No.
And they're 4-wheel
Never.
drive vehicles because there's a lot of constructions and things like that, areas they have to get into. Is that right?
That's correct.
Okay. Okay, fine, that's a legitimate,
Okay.
I wanted to know why we're spending 69 Gs on 4 vehicles. That's a lot of money to
It's a
spend.
fair observation.
But I just wanted to see what that was.
Okay, thank you for your
Thanks, I
comment.
appreciate your help.
Thank you. All right, I'm going to call the council's attention to the consent agenda items. Those are items marked in an asterisk. I do not believe there are any consent agenda items to be added on. Actually, hold on a second.
Resolutions,
Yeah, there are a few.
4950.
We have to add, do we need to make a motion to act on these, to add them on, Mr. Chinesky? I believe we do.
48, 49,
It's 90, 48, 49, 50, and 51, is that right? I would also ask that we make a motion to strike 9B 34. So I'd ask for a motion to add 9B 48, 49, 50, and 51, which are award of contract for dredging equipment to Baltimore Dredger, Chapter 159, Department of Transportation, Safe Corridors Grant Acceptance, and an authorization of the submission and acceptance of another state DOT grant. 9B51 is to authorize Brinkerhoff to do the study on Tinton Falls Road, and 9B34 is being pulled at the recommendation of the manager.
And 9B47.
No, they asked, I'm sorry, 9B47 is also to be struck.
Correct.
So I'd ask someone, please move that in motion.
So moved, Mayor.
We need a second?
Second.
Any comments? All right, hearing none, roll call, please, on the add-on adjustments.
Mr. Malavey?
Mr. Malavey unfortunately had to leave for personal reasons.
Absent of chamber.
Mrs. Showmaker?
Yes.
I'm sorry, did you say?
She
Yes.
said yes.
Mr.
Forgot my-
Tabasco?
Did you forget my name already?
No, she didn't hear Mrs. Showmaker.
Yes.
Mr. Walsh?
Yes.
Mayor DeBella?
Yes. All right, with respect to 9B, does anyone wish to have any separate motions or separate roll calls, if you will, on any of the consent agenda 9B items? And I'll give the council a minute just to re-review these. These were workshopped at our prior meeting.
I just noticed that 9B47 wasn't actually on, so we pulled something that was going to be added, but it wasn't actually on. Does that matter? I mean, from a protocol perspective.
That was a hold. What's that?
My notes indicate that was put on for a hold, 9B47.
But it wasn't added to begin with, though. We were going to add it, but we didn't add it.
We're okay?
Now it's a double hold.
So we're okay. All right, are there any questions, comments, or concerns with respect to any of the consent agenda items?
Yeah, I would like just to ask a question on 9B10.
Go right ahead.
Why are we switching tree trimming services? Any particular reason?
I guess this is for Mr. Nunziato, is that right?
Well, in the backup, and there was several reasons, one of which I think there were some deficiencies in the paperwork as far as the bidding was concerned. And there was some, I think 3 attempts were made to try to rectify it, and it was deemed an unresponsive bidder.
Mr. Chinesky, you had anything to add?
Basically an unresponsive bidder.
Unresponsive bidder.
Okay.
Any other questions on any of the 9B items?
So that'll be rebid at some point in the future?
Exactly.
Right.
All right, any separate roll calls on any of these items? All right, hearing none, I'd like to entertain a motion, please, for the 9B consent agenda items,
So in the motions?
and including the motions, of course.
So moved, Mayor.
All right, we have a motion, we need a second, please.
Second.
Motion and a second. Any final remarks? Hearing none, roll call, please.
Mrs. Showmaker?
Yes.
Mr. Tabasco?
Yes.
Mr. Walsh?
Yes.
Mayor DeBella?
Yes. All right, I call the council's attention to Section 8, unfinished business. We have a variety of measures with respect to ordinances. Mr. Newcomb, I think you might want to come up to the front of the room, if you will, because we're probably going to be calling on you to answer some technical questions. The first is 8A1, 00648. This was introduced on October 17th. Public hearing and the adoption, or potential adoption, is slated for this evening. The explanatory statement, of course, is this ordinance amends Chapter 188 of the Land Use Law as it applies to various zoning districts and requirements. And I just get everyone's
You want to,
material together. Hold on one second.
got it?
I have it here.
All right, ordinance 00649, introduced and passed on first reading on October 17, 2006, and published according to law, is now being taken upon for further consideration and public hearing. Affidavit of the publication of the ordinance in the Asbury Park Press issue of October 2106 is submitted, and is noted that a copy of the ordinance has been posted on the bulletin board in the municipal building, and the copies are available to the general public upon request. Ms. Woolman, would you please read the title of the ordinance?
An ordinance of the Township of Howell, Monmouth County, New Jersey, amending Chapter 188 Land Use as it applies to various zoning districts and requirements.
Okay, I'm going to open up the meeting to the general public for a hearing, remarks, comments for or against the final adoption of this ordinance. Anyone who'd like to be heard, please come forward, state your name and address for the record. Mr. Smith, by show of hands, who else would like to be heard on this particular item? Okay? Very well. Mr. Smith, good evening.
Don Smith, 54 Vanderveer Road, Howell Township. First of all, we're going to start right from the beginning here. Regarding the change from ARE1 to R1, I notice under conditional uses, that's paragraph 3, subparagraph initial D, club pools. How did this get in here? I was at every single master plan hearing, and I never heard this voted upon by the planning board. And I might add that at the last planning board meeting, when the planning board was asked to comment on this ordinance, they commented that it was consistent with the master plan. Now, as I go on through a few other items, I'm going to mention, too, that they were not discussed nor voted upon by the planning board for the master plan.
All right, Mr. Newcomb, would you kindly introduce yourself, and if you would respond to, from a historical perspective, to Mr. Smith's inquiry for us, please?
Okay. This item has basically been included. I'm not only the township planner, but I'm also the board planner for the planning board. And one of our assignments was, in terms of doing the master plan, the land use plan, and the conservation plan revisions, what we did, our firm did, was we simultaneously drafted ordinances that would implement the policies of the plan, of the land use plan, and also of the conservation plan. This item that Mr. Smith is referring to has been in documents that have been shared with the planning board through 9 public hearings. All right, this item has basically been included. So it was moved as a recommendation from the planning board to the township council, and pretty much, is the language that the planning board basically acted.
So you're saying the planning board has seen this?
The planning board has seen this since the first day, since June of 2005.
And, it's not reflected in the minutes where the planning board actually made a vote on club pools. That's what confuses me.
I guess the only thing, Mr. Smith...
I'll go back through the minutes again.
Sure. The only thing I can tell you, having been at virtually all those meetings, there were several things, as you know, that were talked about, and I don't know that we went over and individually approved, if you will, each of the line items that may have been included in the text. Your point is very well taken.
You would have to make it a part of the master plan, though.
Well, not necessarily. I think if we adopted the document as a whole, and adopted a section as a whole.
I think it should be taken. What we've done, as you know, all right, we developed ordinances to implement the policies of the plan from the very start of public hearings, which started in August of 2005. All right, so this language has been handed to planning board members repeatedly in terms of different revisions, and, if board members had a concern about it, they should have raised it, during those 9 public hearings that we conducted.
I have a very hard time that this wasn't discussed and voted on, because in August, September, and October of 2005, we had very heated debates at the zoning board about somebody wanted to put a pool club in an ARE2 zone. Okay, it was all over the newspapers. People were talking about it all over town. And why this wasn't brought up and voted on verbally is beyond me. And does it have to be, in order to be put in the master plan? Does it have to be brought up, discussed, and voted on, or no, you can just put in anything and not discuss it?
Well, I think, preparing material and giving it to board members for them to review, all right, I think they should basically be responsible in terms of raising whether they had an issue with this or not.
But so, for me, that's a yes or no question. Does it have to be discussed, or does it have to be voted on?
Well, it is.
Well, let me...
Yes or no?
No, I mean, we did not go through every item on this list and say yay or nay. And
Mr.
so I
Newcomb-
guess the answer is no.
Mr. Newcomb, where in this, what page, or Mr. Smith, is the club pools? My book tonight didn't have a
It doesn't have page numbers.
No, but in the ordinance, all right, it would be the second page under conditional uses, all right, would be club pools.
Okay, let me just make a point, and I don't have a problem one way or the other on this, but I can tell you, we never individually voted on houses of worship either. We never individually voted on schools with state-approved curriculum. We never individually voted on home occupations being regulated in the chapter. I mean, I think the point is, we all received this material in its totality, and as board members had time to review it, digest it, go over it. Many of these were talked about, but in fairness, I don't know that we singled out any one of these items individually and said, let's vote on Section 2, Article B1, and go down the list, because those meetings wouldn't have been 8 meetings, they would have been 108 meetings. Now, I'm not suggesting that there should not have been or there wasn't discussion on it, but I think in fairness to the planning board, all of these things had every opportunity to be raised and to be talked about.
But my point is, adding the club pools, that was a change. The houses of worship was not a change. There's others that were not changed. Some of these are even mandatory by MLUL.
I have a very hard time
Well,
that this was added, not discussed, and not voted on, especially because of the climate at the time. It's not like it wasn't an issue in Howell Township. It was a very big issue in Howell Township. It happened to be with my neighbors, okay? We hired attorneys. We presented our case to the zoning board, and it got voted down. So it's not like it was a non-issue at the time. And that it wasn't discussed is just beyond me.
So, Mr. Smith, your concern is you're not in favor of that being in this?
That's one of them.
Okay,
Now,
keep going.
You can hammer that out later, but I might add that the Environmental Commission opposed that, and I was present at all of the hearings and testified on behalf of the Environmental Commission opposing that pool site. Still under R1, I'll go to subparagraph E under that too, which reads, properties lying within the R1 district are set forth in the attached Schedule 4. Now, I'll go to attached Schedule 4, and it starts right off, Block 42, Lot 60, new zone, R1, previous zone, ARE2. It's Easy Street, and it lists the name of the owner. We're actually changing zoning with this ordinance?
Yes, we are.
Were these people notified? Were they sent their registered letters?
No. We have done this we have done this under what is referred to as a super notice, which is the adoption of a periodic reexamination report by the planning board, which was adopted in December of 2005.
You realize that you have 73 lots going from ARE2 to R1. You're doubling the density. And these people don't even know it? Is this backdoor zoning? I mean, you're going to hear from other people. But I just want you to understand my feeling, because I believe that this is backdoor zoning. And this happened, I believe it was 1989. People were very comfortable with our master plan. It kept this ARE2. I was one of them. I believed that the master plan, we were ARE2, we were safe. And then, lo and behold, right around Christmas time, there was a council meeting and they did the rezoning map. And wow, all of a sudden, here is R2, which is 2 buildings per acre. Now you know how I felt and why I feel that these people in Howell Township are going to feel the same way.
Mr. Newcomb, I have to admit, I'm not completely thrilled here that these people didn't get individually notified. I mean, well, why is that the case?
A decision was made, all right, we discussed this, all right, that we would fall under, we would basically do the rezoning under this, what is referred to as the super notice, by the planning board acting in terms of adopting a periodic reexamination report, which it did, which it basically attaches to it its land use map, which basically reflects what the changes are that are taking place right here.
The land use map.
There was
really
public
tell what it
comment,
is.
public comment was received on the reexamination report through not 9 public hearings, but I would say 6 public hearings. It was a document which was, all aired as part of public hearing, and several people used it in terms of, making comments about it.
I have a problem. I don't know whether the problem is with the minutes from the master plan meeting or what, but, most of these things like there's one in here, you have, under the SED, there was a property on Fairfield Road, belongs to Mr. Abate. He came forward and asked for a zoning change from ARE6 to SED. It was discussed by the planning board, and the planning board took a vote and said, yes, we'll go from ARE6 to 6. Discussed, voted upon. I can't find any records of these properties on SED being, I see where a couple people came up and they wanted to talk about it, they wanted the rezoning, but I don't see where it was discussed and specifically voted on. Now, some of you are saying that you don't have to vote specifically, but really, that's what I was watching, that's what I really count, is when the planning board would take an area and then say, okay, what do we want to do? And then a motion to be made, second, you'd vote on. That happened on the SED on the Okerson Road, Howell Road section. And there was an individual that came forward, he wanted to stay SED. The proposal was originally to go to ARE6. But the planning board as a whole voted to keep it SED rather than change it to the ARE6. Fine, I could understand that. It was discussed and voted upon. But while we're talking about the ACD, I find another section here where Mr. Saker on Vanderveer Road, which is the road I live on, I'm very familiar with, and I believe that's in Schedule 6. There's a few of them in 6. Well, there's so many in the SED. Okay, here we are. It's pretty near the end of the SED listings, but it's Block 168, Lot 3604. It's going from ARE6 to SED1. Saker Associates is the owner. It's located on Vanderveer Road. I never saw anybody there come before the planning board at the master plan hearings and ask that to be changed. It may have been done by mail, but it was not discussed to the best of my knowledge. All of a sudden, this piece of property, which is right next to the industrial park there, those of us that lived there for a while, we refer to it as the Kane Farm. Originally, it was the original Vanderveer Farm. All of a sudden, I saw where this is starting to show up in some maps as being SED, and
Mr.
where did
Smith,
it come from?
if I can, I want to comment on that, because I see Mr. Bongiovanni back there, and I believe that was part of the comment when Mr. Bongiovanni was forward. Wasn't that property as a part of the court order? Mr.
If it was an error because that was zoned ARE6 in 1989.
Mr. Newcomb, was that particular, I don't know the lot in the block, but we had a court order which included all of Mr. Bongiovanni's clients, and I believe two other.
Yes, is that right?
Mrs. Smith, I'm talking to Mr. Newcomb. But was that not part of our court order? Because I remember asking about that that parcel.
I believe that was part of one of the ordinances that was basically overturned. I think.
I'd like to know the correct
Well, then
answer on that one.
I guess as a resident, I have the right to challenge a judge that made that decision then. Sure. So based on that, I would like a copy of that judge's rendering of that decision. Because I will follow through, because that was zoned ARE6 in 1989.
asked that question,
And it was never changed from that.
All right, can we look into, Mr. Newcomb, I have the same recollection Mrs. Showmaker did, being at all those meetings, that was part of a court order, and that was why that was
I
anticipated.
will get a copy of the ordinance
Okay.
to Mr.
Copy of the order, okay.
Well, what would have caused us to change this? If you don't have the court order, what would have caused this change on this isolated piece of property from ARE6 to SED?
We followed three ordinances that the township had adopted that basically were covered by the judge in terms of his decision. All right, we made maps, we basically showed them to the planning board, in terms of what properties were affected, all right, in terms of and how they would change, all right, and the board made a decision to basically follow the order in terms of going back to the prior zoning.
What court decision was this? Was this?
We're going to, Mr. Bongiovanni is here, he's going to answer that question for us.
Yeah, because
Why don't you, hold on.
I have a question also
Okay,
about that.
hold on. Mr. Bongiovanni, why don't you come up, if you wouldn't mind introducing yourself, if you don't mind, just because we want to finish with Mr. Smith, if you could just give us as abbreviated a reply as possible on this point, we'd appreciate it,
Hi,
please.
Don. I was also, ladies and gentlemen, I was also at the master plan hearings, too. And Mr. Smith is right that nobody appeared for Mr. Saker during those hearings. But I believe this is the same property that Vince Halloran handled. It was a companion case with our cases, the Tantillo and various other plaintiffs. As a matter of fact, they were also combined with the case involving U.S. Homes. So all those cases, and Elon Associates, so all those cases were heard together, so that's why I'm familiar with it. And unless there was a mistake, and I doubt there was a mistake in the schedule identifying the property, that's probably the same property that was part of that lawsuit where the court ordered that the 6-acre zoning be stricken and that the classification that now appears on the schedule be imposed by the court's final judgment. So that was part of the final judgment. Nobody's ever appealed that final judgment, including the township or any other citizen. So I think that is part of the law, and I think what the attempt to do by the planning board in this regard was simply to follow the law on that subject.
Good, thank you, Mr. Bongiovanni. What else you have, Mr. Smith?
I go back to that, though. From what I saw of that judgment, it was only referring to that, and I forget the exact year, 2000 and something, that zoning change that took place then. And this was not changed in that zoning round. It was changed long before that.
Well,
So evidently, somebody at the township level didn't do their homework, checking every lot and block in that judge's order, and just assumed that it was correct. Because I don't believe that the judge would overturn a 1989 zoning based on the 2000, and I forget the exact year, it was 2000 or 2001.
All right, Mr. Bongiovanni, what else can you add for the benefit of the public, please?
What the plaintiff's attorney did in that case was said, because you rezoned my property, I can now ask the court for any other zoning classification that I can prove is the appropriate one under the MLU. So that's, he asked the court to set aside the ordinance, and also to give him the opportunity to prove that the proper zoning for that property was, as it appears today, SED. That was the plaintiff's case. It was slightly different from everybody else's because, as Mr. Smith says, the property was not zoned ARE 6, I believe, at that it was not rezoned ARE 6 at that time, but it was the subject of an ordinance.
Okay.
And therefore, the court had jurisdiction to change it, and the court did change it back to the SED.
Thank you, Mr. Bongiovanni. What else do you have, Mr.
I
Smith?
guess I have to thank the judges and challenge that, because I'm just fed up with these people doing our zoning for us. Also under SED, the bulk dimensional requirements. I notice it shows up as maximum impervious coverage, 85%. Well, I really don't recall this being 85% all these years. I could be wrong. I haven't looked in one of the old land use ordinance books. However, 85% impervious coverage in an SED zone, if you look at the zoning map and look and see where all the SED zones are in Howell Township, you will find the vast majority of them in environmentally sensitive areas where there's headwaters of streams, streams themselves. The one we just talked about, 3 streams, Fox, Dove, and Ardena Brook are in the corner of that property. Longbrook is on the other side of it, of the industrial park right now. All those streams in an SED zone, and you're going to let them have 85% impervious coverage. Fairfield Road, you've got streams down there. The headwaters at the railroad tracks for Ardena and Dove. Yellowbrook Road, you've got the streams through there, Yellowbrook. I mean, it's just ludicrous to have 70% impervious coverage along the frontage of Route 9, where there's even where there's no streams at all, and yet when you get to the environmentally sensitive areas where you put your SED, and that's why the SED was put there, was because you could put rather clean ratables. I mean, Okerson Road is a prime example. Warehouses, electrical storehouses, things like that don't impact the environment to any great extent. But all of a sudden, 85%. Now, I think got to take another look at that. There's other properties in the SED, again, that on Yellowbrook Road, I noticed there's a couple. Stavola's going from ARE 6 to SED 1. There's another one that I just question, and that's on Yellowbrook Road also. And it's going from ARE 2 to SED 3. And I don't see any definition of SED 3.
SED, it was a typo.
Okay.
It's SED 2.
Okay, so I believe that's Raven Associates LLC. Yeah, there it is. Okay, so that's SED 2. Okay, so there's 2 changes there, and the neighbors never notified. And that's my biggest complaint, that the neighbors never saw this coming. And that's why you don't really have a heck of a lot of people here, because nobody knew what was coming down the pike. We saw an ordinance that we just read the first part of it. Looked rather benign. Start looking at the attachments, and then the bells and the whistles go off. This can't fly. You got to have some kind of a conscience. I mean, what do you think the people are going to believe? That this was done up front? They're going to believe the story that we're being told, that it can be done this way without notifying the people? Do you really think they're going to buy that in this climate? I don't know.
Thank you, Mr. Smith. Who else would like to speak on this? Mrs. Dixell, come on up.
I have a couple questions I'd like to ask. Ms. Nunziata, we went through a couple things about that Tantillo case, and you showed me a map that only 9 homes were rezoned back to 2-acre zoning. Is that not correct?
That was a direction I was given from our attorney, yes.
Right, me and you went through that. So were all these areas rezoned, or are they all 2 acres? I mean, I need a little help here.
What's your question? I'm not sure.
Me and Mr. Nunziata went through this about the Tantillo case, and he showed me a map that only 9 homes were rezoned back to 2 acres per the judge's decision.
That's right.
Is that correct?
On that case, yeah.
So all the other homes in that area that were rezoned to 6 acre at the time are 6 acre.
For now.
Oh, what are they?
No.
If you're asking what the new master plan says, that could be different, but for now, they are still 6 acres.
Mr. Newcomb, why don't you please comment?
Okay. Mr. Nunziata, the map that he basically changed, all right, was at the direction of a deputy township attorney, or counsel. All right, the planning board basically reviewed that action, all right, looked at the ordinances that the judge basically declared null and void, all right, and made a decision to basically change the land use map in the master plan to reflect all the properties that were basically, covered by the 3 ordinances that were in effect, that basically were acted on by the judge. All right, the planning board, in essence, made a decision to have those ordinances, or those properties go back to whatever the zoning was prior to the prior to the adoption of those ordinances. All right, so the land use plan, all right, that was adopted by the planning board reflected these properties that you're seeing changing tonight. All right, and in essence, we had many public hearings over it. We had numerous hearings where, the planning board, took deliberate actions and heard testimony given by many of the parties that you're hearing testimony here from this evening on those items, and, adopted that land use map, forwarded it on to council for its consideration. This is just part of it. The decision was made when we introduced this, if you recall. Mr. Snyder and I basically met before you back in June, and we discussed the approach the different approaches we could take in terms of notifying individuals, since we felt that the reexamination report enacted the super notice requirements of the law so that individual property owners would not have to receive an individual piece of paper in terms of the actual notice, and that we took even further measures. All right, we made a decision to put the land use changes on the township's website, not only the map in terms of properties that would be changed, but also to list all these individual properties. And if you go to the website since June, all right, you could click on that and basically see these individual property owners that have been there, like I said, since that point in time. So that's the action that we took, and we discussed that with you, all right, back in the early part of June.
I have no problem with the notices, we did discuss that. Okay? Where's the inherent good to the Township of Howell and citizens going from ARE 2 to 1?
ARE 2, if you go through those properties, all right, those individual properties, you will see that only probably 2 of them are vacant land, all right, or 3 of them are actual vacant land. The rest of those properties are residential uses. In other words, there is a house on those properties, all right, existing, all right? And what you will find, if you go further examination, you look at those properties, you will find that they are 1-acre lots. All right? They were improperly zoned beforehand.
So
They were marked as AR, they were identified as AR2, and a number of those properties, especially coming up Newton's Corner Road and Easy Street in that area, are all 1-acre lots, all right? And they have existing homes on them. So, I mean,
I spoke to someone who's on that list today, and that's one of the houses you have identified in this list, and he's on 3-acre, and his first thing was, great, I'll knock my house down now because I go from ARE2 to R1, now I can put 3 houses up.
Well, you may have those individual type situations,
You
but,
can have a bunch.
well,
Well, why would we be doing that?
Easy Street's gonna become Route 9.
It doesn't go all the way up Easy Street.
There's a bunch of houses on Easy Street on that
I mean,
list.
but what is the inherent good to this township of rezoning them from ARE2 down to ARE1? What is the good to this township?
And in terms of that, to the township and to the property owners, it reflects what they basically are. And I would say 95% of them are 1 acre lots.
What is the good to this township rezoning all this? I don't care what they are. I mean, help me.
The inherent good is that you're basically reflecting what the land basically holds in terms of individual properties. It's the reason for this was to basically reflect the 1 acre zoning that is in that area.
Let me make a recommendation. We all have comments from the council perspective. Why don't we hear from the public? Let's let the people get their comments out, and then we can all ask our respective comments, because in the public's dialogue, we may get some of our questions answered. Is that fair enough, everybody?
I think,
Absolutely.
I
Okay.
think so, otherwise we're not going to get
Mrs.
through this.
Dixell, why don't you, go ahead, please, give us your questions on this particular ordinance.
Barbara Dixell, Howell Township, the Villages. I have a question for Fairfield Road. I know that the Vogel property has changed hands, the new owners on the Vogel property, right?
That's correct.
Okay,
Yeah.
because you had some guy come in here when you sent him home to redo his,
Yeah.
okay. Is that on this list?
No, because absolutely, no, that's got...
Is that owner on this list? Because I don't know, in other
Different
words-
area, that's...
Because it
that's
says
not this.
Fairfield Road, but I'm not sure, no, there's people listed, there's the owners listed.
It is absolutely not that property.
That property is HD2.
Yeah, that's a highway zone.
Okay, then, the only thing I'm going to say is that it's my opinion that changing the zoning of people's property without proper notification could open Howell Township up to many lawsuits and could possibly be illegal. And the only thing is, it should have been voted on each section by the planning board as it was done, and not just thrown out tonight. And I do believe, it's my opinion, that a lot of this will just create additional housing development, which we don't need.
Thank you, Mrs. Dixell. Who else would like to be heard? Mr. Tintillo, and then we'll get to you, ma'am, next. Mr. Magid, we'll get to everybody. Who still would like to be heard on this? Okay. Okay, we'll get to everybody.
Vinny Tantillo, Casino Drive. I ain't got much to say. Has anybody been to Staten Island lately? I came from there 44 years ago and moved here. And this is exactly what happened over there. And when Mr. Newcomb says they go from ARE3 or 2 and go down to R1, what do you think happened in Staten Island? They knocked the house down and built 3 more. So now, instead of 1 house, you had 2 or you had 3 in the same place. What's to stop it from happening here?
Is that a question? Hello?
Yeah.
All right, we don't have to be disrespectful. You're asking a question, what's to stop someone from knocking down the property and putting up 3 houses? Mr. Newcomb, how many lots would fall into that situation?
Well, I mean, if we're concerned about the ARE2, I mean, you're talking about 30 properties. In essence, that would be basically doing that.
So there's 30, hold on a second, there's 30 properties where someone could knock it down and put 3 houses up.
Well, I guess, I mean, I don't have the acreage here. I mean,
Okay.
Mr. Howell identified one property owner that has 3 acres, all right? I would say he is probably in the minority of properties in that area. Most of the other ones that we identified, for the planning board were, properties that were already 1 acre lots. So, they're the ones that, in essence, we recommended to change. Now, there could be a property that's captured, between several 1 acre lots, all right, that maybe has 2 or 3 acres. I mean, that does happen. But to keep it consistent, you usually, you can't, spot zones, so to speak, properties.
I thought when you change zones, or you change a master plan, you're supposed to do a transition to see what can happen and what can't happen, what should go here and what should go there. This is your profession, not mine. But don't you do a transit, you make a transition area so things can happen in certain places and things can happen in other
We're
places.
talking about a transition. I mean,
That's what
you're
this is a transition.
absolutely, reflecting what the transition is. The transition is that you have all these 1 acre lots and you're identifying them as 1 acre. That's what you're doing.
You're identifying them as 1 acre lots. We're talking about ARE 3s here.
No,
ARE
we're
2s.
talking about AER, we're talking about the individual concern that was raised is that there are approximately 30 properties that are ARE2 presently are going to R1. So
Okay.
they're changing basically from a 2 acre requirement to a 1 acre requirement.
So they can double the density instead of reducing it.
If they have the property. But I would contend that there isn't that many that have the actual amount of property that we are overtly concerned about.
Excuse me, didn't you just say there was 32 acres?
There
And
are
it would
30
run back-
properties, there are 30 properties, all right, that are presently ARE2 zoned, all right, that we're recommending going to R1. And I'm saying is that...
Okay, hold on one, Mr. Newcomb, hold on a minute. Hold on 1 second, Mr. Newcomb.
It's only one page, believe me.
Okay, folks, I'm going to ask, out of respect, there's another speaker up here. Please don't shout out from the assembly. It's disrespectful to the person.
Okay, 2 pages, I'm sorry.
Everyone,
Okay.
it is this, hold on, Mr.
Okay,
Newcomb.
it is 2 pages, I'm sorry, I
But it is,
apologize.
folks, it is,
What I'm
hold
saying is
on a
that the
minute.
majority of them...
Hold on
are
1
1 acre
second.
lots.
It is disrespectful if you're going to shout out from the audience, because I have to tell you, we pick up all the noise, we can't hear what people are saying. If you have a comment you'd like to make, we will give everyone a sufficient amount of time to make their point. We're all on the same team here. We don't have to be disrespectful to one another. Shouting out is not the way we're going to conduct this meeting. If you have something you'd like to add to the record, I will acknowledge you, you can come up, and you can be heard.
I missed the
If you
page.
can't do that, I would ask that you please excuse yourself from the chamber and then come back. I don't think that's an unreasonable request. Any member of the council disagree with what I've just asked?
Absolutely not.
Okay, so everyone is in agreement with what I've just suggested. Mr. Newcomb, please proceed.
Okay. And I would only say that only under classifications, under property classifications, only 9 of those properties are either in farmland assessed or are, in vacant land classification. The rest are in residential uses.
All right, what else do you have, Mr. Tintillo?
Okay, well, the farmland assessed is simply that, it's assessed as a farm. But if they want to sell it, if it's in R1, they certainly can go to 1 acre for each house. Because that's what you're telling them they could do. I mean, we're supposed to be reducing density. That's what this is all about. And it seems to me it's just increasing density.
That's not the only purpose for a master plan.
Yeah, I mean, if we really wanted to
That's
reduce
what we're
density,
talking about
we
here.
would go to
Not the
6
only-
acre zoning, but that got sued and overturned. So if we really want to talk about reducing density, we wouldn't be challenging the 6 acre zone in certain areas where that would have a dramatic impact on reducing high density.
Now, one of us up here,
You're right, but there comes a time when you have to chime in.
yeah, but there's not one of us up here that said we wanted to see more development. And this is down zoning to permit more development. There's no other way to look at it. And there's no need for it.
But
There's no need in this
But
section of town.
Bob, that's blanket statement you made about all of us, not one of us up here, that's not right either.
Oh, you were going to fight over development. Development of tomorrow is going to be done by the planning today.
I've said this all 4 years I've been up here. This town will be built out to about 60,000 people in the year 2025, 2030. We came in here with a vision that there should be certain accommodations for the population that exists now and exists 20 years from now, and you should plan to that. To say you don't want any development, first of all, it's
I didn't
impossible.
say that.
You did say that. You said we all
I said
said...
stop overdevelopment.
There's no such thing as
All right,
overdevelopment.
folks, we're going to move on. Mr. Tintillo, what other comments do you have on this particular ordinance?
That's it, I think I made my point.
Okay, great. Who else would like to be heard on this? You know what, Mr. Hammer, before you do that, we're going to, ladies first. This lady in the red shirt actually had her hand up first, and then you'll be next, Mr. Hammer. Come on up, ma'am. Good evening.
Good evening.
Just give us your name and address, please.
Evelyn Gillette, 68 Easy Street.
Hello, Ms. Gillette.
Hello. Well, first, I'd like to commend most of you for your patience. I know it's a long night. To try and keep things brief, a lot of what has already been said, I do agree with. As a resident of EC Street, most of the houses on the upper end, what we would call the upper end, the residents, east of the S-curve, for further clarification, are more than 1 acre. We've got 16-acre farm, we've got a friend with 5 acres up there. Most of them are more than 1 acre. And most of them would probably end up developed. So I'm just agreeing on that point. On the, I lost my place here.
It's okay, take your time.
I'm trying to be brief, though.
That's fine, take your time.
And besides the development aspect of traffic, which has always been addressed, it's been unfortunate in the past with this township that they keep overlooking one thing. And although this is R1 rather than R4, higher density, we keep encroaching on the LNG tanks on Squonkam Road. You've got over 9 million gallons of liquid natural gas in 2 tanks. They were put there because it was a rural area. And that's the reason they were put here. The township fought it when they were put here. I've been in the township since 1964. And, it was put in against our will, basically. The township fought it. But we are stuck with it. You've got a low possibility of ever having complete ignition. But if you ever had complete ignition, you've got an 11-mile kill radius. And they keep developing closer and closer. The Environmental Commission at one time had some radius lines on the zoning maps. They were removed just before everybody started developing.
Just before when?
Before that last bunch of development started
Do you know when that was, roughly what year?
I can't remember the year, but it was back just before they put in Hoffman's.
Is that early 90s?
Yeah, I
Very
would say
early
probably
90s.
early 90s, before they put in the Oak Glen development,
Alright, so that's
in that
real early
area, yeah.
90s. Late 80s.
And those lines were taken off the map.
Okay.
And the recommendation was to keep anything within that area as low density as possible, preferably ARE6 or SED. So that is one of my concerns on that. That and the lack of notification that changes were happening. Unfortunately, a lot of us still don't have the internet, so we can't look stuff up on that and get all this information.
You have dial-up in your...
And you don't even know what to look for if you haven't been notified, You're just fishing. Why would you even think to look?
Okay.
On the LCOS stones, at least one area was previously ARE, NRW, also in the vicinity between Easy Street, Newton's Corner, Squonkam. The NRW is National Resource and Wildlife. It was supposed to be preservation zone. We are pushing the wildlife further and further out. And to start adding the recreation zoning of being able to put in things like ball fields and stuff, you're encroaching more and more. That's a major area for bedding for deer. The area that you just developed for the soccer fields was a major staging area for deer, as was what they call Deerwood Park now, and that development, I can't remember the name of it. Parkside, right, which they lost that area. They moved down the other way more, and now they've lost that. They probably will stage somewhat once everything is settled, but right at the moment, they don't know what to do, and they depended on that farmland for a lot of grazing and picking up the leftover soybeans to survive the winter, that kind of thing. But anyway, it's just to rezone that, LC OS is just more encroachment. I don't see why that area would need to be touched. It's mostly swamp. It is
Well-
absolutely mostly swamp.
Well, the LC in that is land conservation, so I'll let Chuck talk
Right,
more.
but changing that area means changing it to, why can't you just leave it NRW,
Well, let Chuck answer that.
you know? It's mostly swamp area.
Mr. Newcomb, you want to make a comment on that? I mean, it's our prerogative, we can do
One
whatever we
of
want.
the decisions that the planning board said or made in terms of the land use plan was to take county, municipal, and state-owned property and put it in a land conservation open space conservation zone, all right, which in essence would maintain it as open space.
Right. so it'd be staying in
Would
the
not,
state.
change.
So it is going to stay open space.
Basically, what we had the reservoir, we had Alair State Park, places like that in residential zoning. I mean, and that's why, in essence, the decision was made to
So wouldn't this
identify those public land
wouldn't this
areas.
further protect the
I think
the
so.
land from not being
I
able
mean,
to
we've
develop?
used it as part of the inventory that we filed on our Green Acres grants, so it's basically part of the land use inventory that, the township has in terms of open space.
No, because the common term now for open space does not mean preserved natural area. Open space is now ball fields, any kind of active recreational facility that has fields is included in open space, and it's not preserving it for the wildlife. And it's also not preserving that sensitive areas which are part of the Manasquan watershed. And that's also part of my objection to some of the SED, is that they're not taking into account. That's, a lot of these areas are environmentally sensitive, and they're part of the Manasquan watershed. And some of the, besides the 85% impervious, which was earlier mentioned, that's like crazy, some of the businesses that were listed to be okayed for those areas do potentially have hazards that could leak into those environmentally sensitive areas. So I think before passing anything like this, that should be reviewed again too, because, anything that's going to be using chemicals should be kept away from those areas, those SED areas. No matter how careful they are, there's always a potential for a leak. Accidents happen. And thank you for your time.
We appreciate your comments. Thanks for coming out.
Pardon me, Mayor, if, just to remind you, that council always has an option of carrying these hearings on these particular ordinances to the 5th, which is, not a terribly, the agenda for the 5th isn't terribly full, and we can move the issue of the traffic calming policy off that to the next meeting as well. And obviously, it's your call, but I want to remind you that option is available and that the 5th is shaping up to be not terribly heavy.
Yeah, what I'm going to basically do is suggest that we finish the discussion on 8A1 and that we open and carry 8A2, 3, 4, and 5. There's no practical way we're going to be able to get to these in any significant way this evening. Does that pose any difficulty, Mr. Chernietsky?
The attorney advises me as long as you open them.
Right.
And then move to carry them.
So we can open them and then motion to carry them?
Is that correct?
No further notice would be necessary, providing that you do make a motion to move to the specific date.
All right, does any member of the council have an objection to continuing the hearing on 8A1 and then carrying 8A2, 3, 4, 5 until our meeting on December 5th? Mr. DeBasco?
We are going to have to open them, though.
We are going to have to open them, and then we're going to close and carry them. You have any objection to that?
No.
Mr. Walsh, any objection?
I'd like to see them carried to January if at all possible.
I'm sure you would, yeah. I have no objection to that. We can cancel all of these right now if we want and carry them till January.
I'll make a motion that we cancel it now and carry this till January.
Well, why don't we finish the public hearing on 8A, and then we can get a motion and table them all? I think it's a great idea.
Let's finish this.
I think it's a great idea, too. I already made a motion.
Yeah, but unfortunately, under Robert's Rules of Order from a parliamentary procedure, we're in the middle of a public hearing. We want to conclude that public hearing, and then we'll close it, because there's other people who still would like to be heard on it. So I'd like to continue the public hearing unless anyone would like to stop the public hearing on this.
I just have a question about that 884. If you suspend that one, is that going to impact you having the easement for the JCP&L?
Is that a problem on 884 if we were to, I can't imagine that come January, you're going to oppose that, is that right? So there wouldn't be a reason to
No, I just wondered if you don't...
fool around with that one.
Is that going to impact the easement for the lights?
No, it will. It will. So,
All right, so
we could act on that possibly. 884. It's
on 884, so we could act on 884.
Yeah, it'd be a simple matter.
Okay. Well, you know what, in light
You're
of the
amending
comment...
something you did already.
Sure. In light of the comment, I'll entertain a motion to close the public portion on 8A1. If someone would like to motion that. Oh, no, I'm sorry. We got to close the public hearing. So...
No.
Okay.
Yes.
I appreciate all the advice from our novice parliamentarians on the floor. Would we not have to at least close the public portion? Okay, folks, I'm pleading with you. We have a parliamentarian. I don't need all the advice from the floor. Our attorney can handle it. Mr. Magid, just give me a second. We had a discussion that someone would like to move these to January, okay? If we wanted to, could the council close the public hearing now? Mr. Gannon, I only want to hear from you.
You could close the public hearing and then move
To
the
table?
ordinance, either to table or move it for a vote, but again, if you do have people who want to speak on an ordinance, they should be allowed to speak on an ordinance. So that's the question, is it a reasonable period of time that the public hearing is taking place?
I have to say something before we continue this discussion. The master plan was last finished in 1994. We spent considerable amount of money, had meetings after meetings at the planning board for years. At some point, you have to draw a line in the sand and say, we're doing this. And if they want to change it again, you do it at the next time. It's been 12 years. I served 2 of my 4 years on the planning board. For this now to be tabled after all the professionals put all their time, we have the state planner sitting right there. We took from the state, who made all these recommendations. We had debates at the planning board level over and over and over again, ad infinitum. It's the same people sitting there right now who stopped this master plan from happening in 2000, and 2001, 2002, 2003, and now again want to stop it again. I have the floor right now.
Hold on.
Oh, I have a...
All right, so the commentary is we want to keep having a public hearing. Fair statement?
No, that's not the commentary. I want to make the comment I'm making. You are going to... If this carries into January, it'll carry into 2007. Why? Because it's the same people. They made it carry from 2000 to now. There has to be a line drawn. Hey, I have the floor right now.
All right. Okay, so here's what we're going to do.
I'm not wrong. Was the last amendment done in 1994? Yes.
We're going to continue with the public hearing. Mr. Magid, you're up next. Come on up. We're going. We're coming, Mr. Magid.
Let me just add that if you cannot carry the vote to January.
Thank you.
Right.
You can't carry over from one year to the next year.
Exactly.
We'd have to close everything up. It's done.
We're going to do this.
It would be tabled, it would be voted down.
It would be tabled, then have to be introduced.
Come January, this could all be undone.
This could all be undone in January, Mr. Gannon?
Anything can be introduced via new ordinance, and you can change anything at any time.
Mayor, with all due respect, Mr. Gannon?
With all due respect, you should pose your question to the chair, and then we'll go to Mr. Gannon.
Come on now, Mayor.
But Mr. Walsh, you're the one that brought up this issue. Let's hold it till January. I mean, what are we doing here? It's 11:30 at night. Let's get on with the public. Can this be undone by any council at any point in time with a new ordinance?
The ordinances should reflect the master plan. If these ordinances reflect the master plan and they're passed, in order to undo them, you then have to pass an ordinance with a resolution indicating why you're deviating from the master plan.
So it can be done.
Or change the master plan.
There you go, okay. Mr. Magid, what do you have on this, please?
Abe Maggot, 89 Mariners Cove. Well, just a few questions now from Mr. Newcomb. Site 1, how many units per acre is that one?
If you have the information,
Well, I just want to check with you. I have here 4 units per acre. Is
Yes.
that correct, or is it 8?
I think it's 4.
All right, 4, fine. Now, Site 3 is 8 units per acre, and it's, the amount available, 167 acres, is very appreciable. What are they? Are they, well, tell me, are they garden apartments, or why are there so many units per acre?
Okay. These are, first of all, these are Mount Laurel sites that were part of the decision of the township to meet its Round 1 and Round 2 certification.
All right, I understand what you're saying. Now, when you have a Mount Laurel site, and I read the co-op very carefully, and we have to, I believe it's 487 units, but the point is this. When you say Mount Laurel, and I understand it is one, I'm just going to wait till they're finished.
Go ahead, Mr. Magid, we can hear you.
Thank you. I understand there is 1 unit each time required for every 8 market ratables. So therefore, taking the case of Site 3, even though you say it's Mount Laurel or COA as it's known, it means that if we have 8 units, say rather than 4 units, it means that aside from the 1/8 that will be COA. Now, I understand that you can have like 20 units out of 100, but in any case, the ratio still stays as 1 out of 8. It looks to me that, and I heard a comment here about the master plan, we don't concern ourselves that much with density and other considerations. Well, I think a prime consideration, I'm sorry, I'm speaking.
But I didn't say that.
You said that was not the only thing to be...
It's not the only consideration, but I didn't say we don't consider ourselves with density.
I would say majorly, when COA is on our tail for 1 out of 8, we had better see to it that the units we build, to satisfy the COA, the 8 units we build, be the highest possible rateable under this master plan to offset the economic damage which is being thrust upon us by Trenton. So let me continue now. Now, why is that 8 units rather than 4 units?
It's a reflection of at the time, the ordinances were individually adopted per site as they were basically identified, in the housing plans. The ordinances were amended, the township's land use ordinance was amended to reflect a specific density in terms of the properties. Also, I just want to make a comment that most of those projects require 20%.
Yes, I know.
Okay.
I understand.
And that's part of the
But it's
ordinance.
still, whatever's required, it's still, every time you build 8, you're required for another car unit. Now, I still want to say, is that because this particular Site 3 now exists with 8 units per acre? That's what I seem to understand you're saying.
Yeah.
It reflects that area. Well, what are those units? What kind of units are they? I mean, are they apartments? Are they townhouses? Are they condos?
No, we're not.
And how many of those do we have? There's something here that's very strange.
Most of the projects are townhouses.
Well, if that's the case, then in that area, where we have 167, I see that residential is only 29 for 14.6%. And we're going to load up 83.9% because it's already a small amount, like 29 units instead of the 167 coming in, why can't we alter that to be at least 4 units? Because we're going to be buried here with putting in so many units, and there'll be lower ratables because there's 8 units per acre, and every time we put in 8 units, bang, we are obligated to put in another affordable, but even a lesser rateable. Why in the world can't we now proceed in this master plan and say, okay, there's a small amount called 29 units, which is only 14.6%, and 83.9%, 167, let's make that at least 4 units and not 8, even though the units that exist there now, whatever they are, we don't have to continue it, especially with COA coming up. I make that recommendation strongly into the master plan.
Okay.
Now, I don't see any reason why it can't be done, in spite of the fact that a small number are there already, but a number of at least 5, over 5 times as many, 167 versus 29, we will now be building for lower ratables with 8 units, and each time we build them, bang, we have to have another COA come in. I don't suggest, I say strongly, let's change that immediately to whatever we can, less than 8, and certainly 4 would make a lot more sense to me.
Okay. Anything else, Mr. Magid?
Yes, well, I wanted to get a comment whether that can be done.
Well, it can all be done. I mean, everything you're suggesting are they're good ideas.
I thought I'd get a comment from Mr. Newcomb whether
Candidly, it is possible.
Okay.
Mr. Newcomb gives us the recommendations. The policymakers will consider it. Okay? Anything else?
Site 1. Now, Site 1, it says here, has a vacancy for 418 acres. That's a lot of acres. Is already residential on 212. Now, that one is 4 units per acre. I think we discussed that, and that's what you agreed.
He's talking about
But, no, in other words, 66% more, with 33% already done, meaning 200 versus the 400. And that, I understand, is 4 units per acre. Now, that I have a note here, it says garden apartments.
That's what the ordinance allows for.
All right. Well, allows for, it doesn't have to be garden apartments, you mean? Oh, the ordinance says that area has to be garden apartments?
That's what it recommends.
Well, when you say recommend, what's the legality of an ordinance? It recommends or it has to be?
Well, it basically requires.
Required, okay. All right. Now, I see Site 6, for example, is also 4 units, and it says garden apartments. There we only have 5 acres available from vacant land. So, taking that into account, and as you said to me, everything from Site 3 all the way to 9, meaning including Site 1, is all under ML7, which is Mont Laurel COA. However, the other 2 sites are all 4 units, and yet we're going to Site 3, and yet that's 8 units. And again, I made my recommendation, but I can see that we should have that flexibility. Now, let me just go on a little bit more. And by the way, I want to say this. Anytime now, in this master plan, where we can legally, through our decisions, have less density or bigger houses or less units or houses per acre, that acts as a bulwark, because every time we get 8 of any kind, including garden apartments, bang, we have another unit. So let me go on here some more. I do notice that under R3, it says 299 acres available, and that's rather tasty because it does say, that's reasonable, 2.25 units per acre. Am I right on that? Okay. Well, the point is this, just strictly from when we have a master plan, being to some degree realistic and practical in terms of the market, what we'd like the township to be. When you provide that you can have approximately a house on approximately a half acre, that's a draw. I mean, people, I think, will come and say, okay, I'll buy it. And when you have a house like that, only one unit, that goes a long way to offset, let's say you built 8 of those in R3, which you easily could because it's 299 acres, which is great. You have 8 units, bang, Mountain Law comes in and co-on, we have to. I think everything here has to be restudied.
Mr. Maggot, can I interrupt you just for a moment?
Surely.
I'm not sure, but I think that you were at several of our master plan meetings.
No,
You were
I
not?
was there, but I couldn't say a thing. Hardly anything.
Okay.
And I didn't know what was going on at the time, and I wasn't told.
Okay, I would greatly appreciate, because I will tell you, you're jumping all over so many
I'm
many
not,
issues.
I'm being very specific
No,
on each item.
I would like for you to make a point.
Oh, I am.
I mean, but I don't want, and I mean no disrespect like this. but
No
you were
disrespect, I made a point.
At 12, at 11:40.
Oh, I'm sorry, no, this is so important this time. Let me go on, so I appreciate what you're saying. I'll take your advice, but I want to say this. Not only was I very specific, I picked several specific items, and they each illustrated my point exactly. I have just a few more that I want to mention, that I
your
would
time.
want the master plan to realize some where there's benefit against the deleterious action of having 8 units for 167 acres vacant just because it's 29 units in that area. Now, for example, I'm looking at 85 acres for R2, which I take to be 2 units per acre. Now, the reason I'm saying that, I'm answering this board member that just spoke to me is, I have looked at each and every one, but I'm not on the town council. I say that this town council, and I've heard Mr. Damasco say about 1994 and all the work and the master plan. I say this town council now should look at every designator with a view that when COA says 1 unit for every 8 units, wherever we possibly can, to have less than 8 units on an acre, and if possible, have less than 4. I leave that to you. I leave it to your sage wisdom from this point on to take what I've said here tonight and look at item by item specifically to make sure that you can revise this master plan of many meetings so that we are concerned with what COA is doing to us, and haven't even mentioned the fact that when there are 25 workers, in comes another unit. I see a total of approximately 2,000 to 2,200 acres, not counting the public one, the 251 acres. I see about 2,000 to 2,200 acres that one way or another will have what we call units. That's a euphemism for a giant house or a tiny garden apartment house. And I say that this council now, through the responsibility of all the people for many years to come, if we don't change the master plan, do a lot of research on how to bring about more expensive ratables rather than 8 units per acre, just because there were 29 there already in 167. I thank you very much for your time.
Mr. Hammer, come on up, sir.
Mayor, may I make a comment about a conversation we were having previously about voting on things, and
Go ahead.
I do just have a concern as a procedural one in terms of having a master plan in place that specifies particular uses, and not commenting on my preference for uses, but the idea now is you have a master plan that delineates what areas ought to be, and if ordinances aren't adopted that are consistent with them, the township creates an exposure for itself. And I think I would be remiss as your manager not to point that out. At the same time, it's important to acknowledge that there is a new town council that's going to be seated that has different, I think, looks at planning from a different perspective, and they may want to change that, but there's a process to be followed that, in my opinion, minimizes the exposure to the broader community. So I'm not commenting on the merits of the ordinance, but I would just caution you to be very careful about leaving the town exposed by having an inconsistency there.
Okay, thank you. Mr. Hammer, good evening. What do you have for us? Welcome.
Basically, I own the property next to the LNG tanks.
Okay.
And it's been, excuse me, over the years, I've been here 40 years, it's been an ongoing situation.
Mr. Hammer, could you pull the mic a little closer
Oh,
so
I'm sorry,
folks can't
thank
hear you?
you.
That's okay.
I addressed a letter to Bruce Davis as I was instructed to. You may have a copy of this. I don't know if you recall, on October 17th,
Yes.
when this master plan section was first introduced. So what I probably try to do is just read this into the record so that I'm covered as far as my application to change my zoning. I started off by saying, please be advised that after review of the present zoning of my property, Block 41, lots 13, 14, 1401, 1404, 1405, 28 acres, it's become most recently apparent that my property no longer fits the category ARE6 for the following reasons. We're surrounded west and south by the current SED zone, the New Jersey Natural Gas LNG plant, which is a refinery plant. It's really not just a storage. They refine the gas there and add the odor to it. The ongoing operation of this facility directly affects the quality of life living next door, the noise, the odor, the lights, and I mention odor because sometimes the odor machine leaks and it smells like gas, but it's the odor portion that is leaking. The trucking activities, the threat of explosion, the updating and expansion, the sandblasting, the construction, it's an ongoing process all the time. Not an attractive place to build a large one-family home next to it, which 6-acre zone would ask for a large six-figure home. The property, Atlantic Water Body, I don't know if you're familiar with this area, but on the corner of Victory Road and Route 547, received a small variance years ago by its original owner for 4 cars working out of his house. Now there's a towing operation there. They have approximately 40 cars there max at times. Several employees, operation over-intensifies use of 1 acre. The vehicles needing repair or storage are parked the bumper of my property line at this point now. They've taken down all of the trees, regraded the property, and eliminated the buffer between my farmland and their operation. The factors of noise, related activities of the operation are not conducive next to a private home. I have a lot right next to the body shop, and at this point, it would be not desirable to build right next to them. The DeSanti Concrete Products on Victory Road is north and west. It's a large precast concrete operation. It's expanded extensively over the last few years. Approximately 1,000 feet of our property has a large trucking operation going past our property along Victory Road. Also a very large noise factor from mixing concrete, sandblasting, vibration to settle the concrete in the forms goes on daily. The Conrail Railroad is walking distance from our property, and I mention that because in the Section 5, the purpose of the SED zone is to provide for a variety of economic development opportunities in the areas of the township where rail and highway infrastructure is rarely available. Now, I mentioned the railroad. I should also mention that our property fronts on 547, become a major highway now. We have as much traffic probably as Route 33. This has happened over the last few years. Lakewood has developed considerably. A lot of traffic from Lakewood going to the Parkway via I-95. So again, residential, not there anymore. We're on a commercial road. We're in a commercial area. A major county highway running north and south from Lakewood to Interstate I-95. With, I understand there's plans to expand it to 4 lanes. The county is studying the expansion now. The location of my property is more conducive to commercial. That is in the commercial area. I have 1,300 feet frontage on 547, I'm surrounded by commercial activities north, east, south, and west. The LNG plant, south and west, including DeSanti Concrete. The auto body shop is adjacent to two sides of my property. They're on 1 acre, and they've over-intensified the use of the property. I've spoken to code enforcement about it. I don't know what the status is, but, and now I see there's I'm going to speak to the towing, but they have a towing operation, towing all kind of junk cars that sit out along the road, exposed to the passing traffic. Interstate I-95 is about 1.3 miles to the north and direct access from my property. The farming is no longer a viable use of to the congestion, the noise, the car traffic, activity, and the pollution. Our property does not embody a rural agricultural countryside that we've been saddled but between a body shop, the gas plant, and a major highway. And I think the ARE 6 calls for their zone to be in a agricultural countryside. That's not where we're at anymore. It's also, my property is not within any stream, it's not within 300 feet of any border of any stream or 100-year floodplain or of a Category 1 stream. There are no wetlands on my property. It's totally clear. No trees need to be removed. Our property already has a basin and adequate drainage through a culvert under 547 that we, in conjunction with the county and the Mosquito Commission, did years ago. So drainage is not a problem. There are basic utilities available. The sewer line runs in front of our property along 547. There's gas, electric. They just put in a new main down at Maxim Road, so we have access to water. Major highways without going out on the interior roads. As I copied Mr. Gannon, Tom Sinecki, Charles Newcomb, and the mayor and council, I appreciate that you would consider my application.
Thank you for your comments, Mr. Hammer. Yes, sir. Yeah. Come on up, sir. We'll get to you, Mr. Hammer. Come on up. Just give us your name and address for the record.
Hi, my name is John Ray from 72 Vanderveer Road.
Good to see you, Mr. Ray.
How are you?
Good to see you, John.
Hey, Bobby. Just real quick on this new zoning, the SCD1. I live, like I said, at 72 Vanderveer Road. I also own the property directly across the street, 28 acres, which I want to say I bought for the sole reason to stop this insanity that's going on. Because I love my street. I've been there for 17 years. I have 4 children, and put my heart and soul into developing my home there. And I'm disillusioned with the zoning and the protection the town has given me on that street for many issues, which I won't get into right now, to stay on topic. But this directly impacts me very severely or very profoundly in that I do own the property across the street, and my home of 17 years is right there. So I'm referring to, I imagine, the Saker property, which would be under this ordinance. And I have to say, as a resident, naive as I may be, upon entering this meeting, I got a very suspicious feeling from the notification, because I received none about this. And it just sounded like something was happening that wasn't above board. Just an impression, for whatever that's worth or what it isn't worth. But 85%, and I'm not too educated on all these things, but the 85% is going to have a direct impact on me with the water table rising or wherever the water is going to go, and all these things that I see listed here in terms of what would be allowed there. It's going to, there could be contamination of the water with leather manufacturing, and all this other stuff looks bad. My main point is I need some consistency on my street, and there's none with regard to anything, whether it be industrial. This is industrial. It's a residential street, as far as I'm concerned, and we can't mix all this stuff in there And if it is going to be mixed in, I would like to be notified, or all of us would like to be notified, and none of us have. So I would just implore the panel to really look into this and try to stop it, I should say, because I'm directly affected by it, and I'm not too aware of everything that's going on, because I haven't been notified and haven't had the chance to research it or get educated on it. So that's A1, and that's all I really have to say.
Thank you, Mr. Ray. Appreciate your comments. Mrs. Smith, come on up. Good evening. Sure. Who else still here? Mr. Allen, I just wanted to get ladies first. We're going to get to you next. Okay.
And cripples, ladies and cripples. Physically only.
Can't use that word, guy.
Physically only.
Getting around just fine.
Oh, I'm frightened. I don't want to re-injure. And on that note, Pauline Smith, 54 Vanderveer Road, for 43 years. This is so important to me that I came out and jeopardized re-injuring my knee, which would definitely mean surgery. Just an aside, not that it would impact you, but just to let you know how important it is. The first thing, number one, I'm upset because I feel, and with some layman's experience and knowledge, that this was improperly noticed. And I don't mean because you decided to notice the way you did. That's okay. But this, in the newspapers, nowhere, public notice that's necessary for a public hearing, doesn't say zoning change. It says, this ordinance amends Chapter 188, Land Use, as it applies to various zoning districts and requirements. It doesn't say the zoning is to be changed. So I feel that it was not properly noticed, and I think you should pull it, look at it, and for that reason, start over again next year, because there isn't time to renotice and do it again.
Okay.
Mr. Gannon, anything on that?
We're listening to our comments.
And we, go ahead.
I'm not exactly sure what the technical protest is to the notice.
That it doesn't advertise that there is to be a zoning change within this ordinance. That would alert people to read further.
Mr. Newcomb, in your experience, how have other townships done this? I take it your firm has done this, used this form of notification previously?
Yes, we have. We've done it this way. We've done it the other way in terms of individual property owners being notified individually.
Please, to make myself clear, I don't want to waste time, it's late, but just to make myself clear, it's not, my objection is not that you didn't individually
understand.
notice, but what the wording of the notice was.
Okay.
The legal notices that are required. It doesn't indicate to anybody, unless they have inside, and by inside I mean are very informed planning, committees,
Understand.
whatever,
Okay.
reading this, that it would result in a zoning change.
All right,
The
well,
average person would not know.
that's a good
and
point, and I think we noted for the record.
You don't like the word amends?
Amend
Go ahead.
as it applies to various zoning districts and
she's talking about this right here.
requirements.
Okay.
It doesn't say changes.
Okay, we understand your point. What else
I
do you
know,
have?
I was answering Pete's question.
Okay, what else do you have
doesn't
for us?
Okay, several of them. I don't also agree that it's consistent with the master plan, because several of these things, and as you know, but I want to put on record, I participated up until I was not reappointed last year. I was chairman of the master plan subcommittee, and yes, some of these things were in reports that I saw, but I didn't see them discussed. And whether it is legally wrong or ethically and morally wrong, I can't tell you. I think it's a very fine line. But the discussion should have been made in public because not everybody went down and paid for, which I object to, I think it should have been free, for reports that the planning board members saw and might have voted on. So that means, in my opinion, that the public did not have knowledge. I want to get all this on record for a very specific reason. And for that reason, I don't believe that it's consistent with the master plan because it wasn't what the public, even though there were countless hearings and discussions, the public did not have knowledge of it. That's wrong. And consequently, there was not, in past, when we had draft master plans that were available to the public for review, and they didn't have to buy them. They borrowed them, or at one time, more than one time, twice they were given out that I can remember. Been through this process several times in the 20-some years that I've been involved. I don't believe making very clear, I don't believe the public had appropriate knowledge, so it's not consistent with the master plan. There's no written document. You can come up with any kind of reports with any kind of dates on them. We don't have anything to say it was consistent or not. I don't believe that it is. Consequently, I think you should have 4 votes if you do intend to vote on it. You should have a supermajority because you can deviate from the master plan. And it's very simple. You just have to state why you're deviating and have a super majority vote and make a resolution to that effect. That's all it takes.
Okay. What else, Mrs. Smith?
And since it doesn't look like you want to do any of that, my advice would be to pull it and do it right. Pete, there's no sense in doing something, no matter how long it takes, if it's not done properly, and it hurts people.
I object to you saying it's not done properly.
Okay.
Correctly. How about that? Is that a better word?
We understand your comment.
Okay. And since you're going forward, I will have to put on record specifically what in this is this ordinance, and I hope I don't forget anything. I don't like, and I said, and it's my right as an individual now to put on record that I don't approve, but I'm not saying that the R1 wasn't discussed. I think it's a bad idea all the way around because we have so much mixed-up zoning that can't be corrected, and the ARE ones are right next to the ARE 6s and whatever, and the requirements for the standards, use the appropriate term, the standards for Rs are different than the standards for AREs, and I don't think it's fair to the people that live in the ARE zones to be subjected to things that a higher density housing is a different lifestyle and appropriate for that, but not appropriate for the ARE. So for that reason, I object to that. I think it's a very bad idea. And the club pools, I always objected to for that reason. Maybe if we had a lot of open land and we had another area that several hundred houses could be built and a pool could go along with that in a residential zone. But we don't have those kinds of areas open anymore. I don't think that club pools are appropriate anywhere except where they were planned years ago as entertainment in the HD zones.
Mrs. Smith, before you move on, can you just clarify, did you say it was that, even though it was discussed, it's your opinion? Is that?
Yes, that's
okay, I
what
just
I
wanted to
said.
clarify that, thank you.
I'm just making that's my objection as a citizen.
Thank you.
I'm not saying it wasn't.
No, I wanted that.
Anything else, Mrs. Smith?
That it was discussed,
Yes,
taking it down from ARE 2 to R1?
yes.
No, it was not. Just
I just wanted to clarify that.
designating, no.
The designation.
I was getting to that later, just the designation, the change in designation was discussed.
From ARE 1 to R1.
R1, yes,
But
but
you're
not
not-
changing the zoning.
But you're not talking about Easy Street, what I was talking about before, Newton's
No.
Corner, and,
I'll get to that further down.
okay, I just wanted to make sure about that.
Okay. I'm just, just because it's in the ordinance this way, my next subject is principal uses of economic development, special economic development zones, SED, industrial, commercial, whatever you want to call it. For years, and Cindy might remember because she was on the planning board, and Mike might remember, he was on the planning board, Mrs. Schumacher and Mr. Howell, for the record. The planning board, the master plan subcommittee, some of us in general, have been concerned with the SED zones, greatly so, because they're predominantly in environmentally sensitive areas that shouldn't have the intensive building that they do, that an SED zone provides for. So there have been different times through the last 15 or 20 years that that's been modified and hopefully improved so that they would be more compatible with the people who live there and the streams and the wetlands and all the environmental sensitivity. And it's been modified. But what I see here, in my opinion, is outrageous and atrocious. It's the most impact. What jumps out at me right now is manufacturing of electric and electrical equipment. Isn't that what FEL did? And isn't that what led to all the pollution that caused no end of problem and destruction of property and endangered people and animals? There is a long list of things here. It's multiplied many times over. Leather products, we want a tannery. What does that smell like? And what kind of damage does that do to all of these streams? Manufacturing photographic equipment, medical, optical goods, watches, and clocks. I don't know if any of you were here long enough to have been aware of the problems that we've had with contamination and Superfund sites and properties that we've had to clean up from this type of photographic equipment and spills. I mean, maybe they make things differently now, but back then there was a process that had something to do with the silver in the film, and it contaminated the land.
Isn't that the Superfund site we have now on Maxim Southern Road? Isn't that what they used to do there?
Yes, you're right. I was referring to one before that wasn't as, yeah, on Route 9. But it didn't, but you're right. The one that we have now is bad enough. We don't want these things here. This is a quality of life issue. The taxes are bad enough. Most of these aren't ratables anyhow. If we get into that, a ratable, in order to be a ratable, has to subsidize our taxes. And nobody in this township, to my knowledge, who pushes what they call ratables, ever sits down and figures we should have a formula. I've suggested this for years. People think I'm foolish. We should have a formula by which we should sit down and look at something, commercial use, and decide if it pays more taxes than it costs to use the services, or to provide the services, I'm sorry. That would be a ratable, but that's never done. I thought an economic development committee would do that, but unless they do it now, I haven't been in a year or two. But for the years that I sat in, nobody considered that. To me, that's very simple. And when we look at especially the SED zones, the damage to the roads, the impact by all the trucks and equipment far outweighs what they pay in taxes. We're subsidizing them, and I resent the hell out of it in plain English. And most of these things bring more of that in. And the more important thing, and I'll jump over to Saker, I'll get into that more thoroughly later, but I'm going to use that as an example because I see that. This piece of property that they want extended to SED, that, by the way, they've tried over and over again since 1989, and every single planning board has turned them down when they look at the property. The streams on that are there, and they will be destroyed. It will destroy the property adjacent to it, because there's no other way to build on it except to fill it. And they've attempted to do that before. They did do it. They brought hundreds of loads, tandem dump trucks in the middle of the night, because I witnessed it and I complained against it, as did many other people. They're not good neighbors. It was sneaky. It was illegal. They're lucky they got the smack of a hand and like a $500 fine, and they had to pull it all out again. And I have pictures of it, and if anybody wants to see it, I'll dig them out, that I took myself. I can give you a 43-year history, eyewitness history of that piece of property and how they've destroyed it. Never should have been an SED zone. It was one of those political paybacks. And I'm saying that for the record, and I'll talk to a judge.
What year was that?
What year was the contamination, was the...
No, this
the fill?
payback that you talked about.
Oh, a long time ago, please. I'm not talking about you.
No, I know that, I'm just trying to put it in perspective.
It was when it was made an SED zone.
Which was when?
Yeah,
But that's
70s, 80s?
Yes, 70s.
70s.
Late 70s. I think it was late 70s. But the important thing is that they did bring all that fill in, and that they did have to pull it out again, and it was the most disgusting concrete sewer pipes, things you would not, they were in our streams.
Is that the property that's being rezoned now?
This is, yes, this is that specific property,
Same property,
the same property.
okay?
It's all, or most of it, goes up behind other residents, and it's 3 streams. And actually, technically, I think 2 of them are streams and one's a brook, but they're waterways. And members of the Saker organization have gotten up and said, oh, there are no streams there. That's water pushed onto our land from other people filling around us, and it's spill. Well, if you'd like, I can bring you maps from 1850 and 1830-something, and they show those streams. So, I want to get this all on record. I want you to know what you're doing.
Maybe they mean that's what somebody filled them, Paulina.
No, they filled them. And all that, we're not supposed to, at planning board, take anything like that into consideration, but this is a zoning change. And since I'm on that subject, I think the more efficient thing to do, instead of jumping back and forth, is to finish it. The court order, I've read it from cover to cover. I didn't see anything specifically about this piece of land. Now, don't you think with as aware of it as I am, I would see that? I'm not perfect. Maybe I'd missed it. But I don't think this should be voted on until that order is reviewed, and if it specifically says that piece of property, because it's a totally different circumstance than the others.
Mrs. Smith, I gotta tell you one thing, there's no chance we're voting on this tonight, so be assured of that. It's just not, it's not possible. We're gonna finish the public hearing. We haven't even had deliberation among the council members.
Okay.
I'm definitely not capable right now.
Go ahead, Mrs. Smith, I'm sorry to interrupt.
That's okay. I just want to also remind you that you were sitting on council the last time, except for Mr. Walsh, excuse me. The last time that this came up, I believe it was 2003. And there was a public hearing. They requested a zoning change. I believe Mr. Ray spoke. I know a couple of other residents spoke.
I don't recall.
And we spoke.
This is when the original zone change was done.
No, it wasn't. Not the original zone change.
No, the one that's being reverted. Pauline, you're talking about the one that was done, that is, the judge is...
No, I'm talking about a separate, after that, they asked for it to be changed to SED, and you voted it down. You, 3 council,
Sure, okay.
I remember because
Of
it's
course.
my home.
You mean the
I don't
sacred
expect
property.
you to
Sacred
property.
remember
Sacred.
everything, but you can check on it.
I'm sure you're right.
And you saw the wisdom of it remaining ARE 6. So please check on that. That's the most recent. There were reports, I believe the Sheehan firm was the township planner then.
Well, it may have been,
or-
just by way of record, too, it may have been that we wanted to do it as part of the master plan and not as a spot zoning thing, too. And that we have his recommendation tell us otherwise.
Let her stay.
Go ahead, Mrs. Smith, what else do you have? Do you have much more, Mrs. Smith, just so we can get to,
a little more, but several things I want to get on record for specific reasons because I feel this is so, not the idea of certain things, but the totality. And I wonder how well you workshopped it and reviewed it, because these things should not be done quickly. It's too important. There are too many lives. These are people's homes and lives. The quality of our life means a lot to us. We pay a lot here. We pay a lot anywhere today. All I want, and I'm going to speak for me personally, all I want for the rest of my life is to be able to live in my little house on Vanderveer Road that has seen life and death and sadness and happiness, and it's my comfort, and I'm sure that everybody else feels the same way. And we need that protection. And having manufacturing leather products, and another thing that I'd like to see, back to the uses, permitted uses. Under accessory uses, quote, "Outdoor storage shall be permitted in a screened rear yard only." Well, I've already, and other people have, and other people will, emphasize the environmental sensitivity of most SED zones. That, it should be screened, and if it is, there's an awful lot that can leak from things stored to accomplish these uses. It should be much more extensive than that. It should be something like concrete and some kind of covering to make it, I'm not being unreasonable, I'm just,
we appreciate your comments, we take it under advisement.
okay. And I'd like to see some of these, because we did make, we as a, let me emphasize the we's, because the we's go in lots of categories, and I do apologize for that. Just to keep up with it. We, residents, committees, land use committees, to several different boards and commission, and the commission, and the master plan subcommittee have made recommendations, have tried to have, as I said before, a list of uses that would be fair but could be lived with. The SED zones were chosen, this description here, that I want to address that also, that talks about highway infrastructure and railroads. Well, the railroad was already dead when this was established. It was over 30 years ago. We haven't seen, if a train went by once in 2 weeks and it sounded really neat going through the woods, we smiled. The trains used to stop for us at Howell Road when there were trains. So zoning, because the railroad is there, is ridiculous. Because the railroad isn't there, and if it ever is going to be, it's going to be another 30 years, not in our lifetime. Because what you're zoning for is people. The SED zone has residents, existing houses, pre-existing houses, some lovely houses, some farms. Those people have rights. Now, I see names listed in an SED zone, for instance, people that I know personally who have sent letters in for several years, who live in the houses north and south of Route 33 on Howell, 5 Points Road. They were just set aside. Nobody ever acknowledged them. Nobody discussed it. Nobody considered their request to be in an agricultural residential zone, just to cut them out. Some of the houses are historic. It doesn't matter to a lot of people. It matters to most of us. And we are the people that you're supposed to represent. And that's another we, all the people of Howell Township. There's a historic church, there's a cemetery in an SED zone, the same one on Route 33. Those could have been cut out of the SED zone and protected, but there are several letters. They're just put aside, because I brought them up at Planning Board myself over the years when the letters came. Please pay attention to this under, and it never was. It wasn't considered. But people came in. We had 12 people object to the ARE 6 zones. They didn't want their property zoned for, and they didn't give good reasons. They gave economic reasons, which we are not supposed to consider. And of those 12 people, half of them are speculators, call themselves farmers, but they're only land speculators. At least 3 of them already have approvals before the planning board on that land that we didn't upgrade. 3 more have them pending, 1 twice to make a subdivision even more intense than the first one. Maybe 3 out of the 12 were really honest in what they said to us. But because those people got up and spoke, there was no 6-acre zoning in the area.
So you want 6-acre zoning?
Well, I'd like to see 6-acre zoning, but I use that as an example.
Right.
At this point in time, I'm not saying that.
Would you also like to see TDRs? So we could transfer some of the development rights over?
If they're possible, they're kind of difficult, and they take work, but they're worthwhile if they take work. If they work.
It's great for the
No,
person in
I'm
the
not,
receiving zone.
I'm not talking about blanket 6-acre zoning. You have all said yourself that we, approved of the 6-acre
But
zone.
the Casino Drive area, you were in favor of 6-acre?
Yes, because
right.
of the environmental sensitivity of
Right.
the, on this Saker property, on the SED zones, part of Fairfield Road. We have streams, we have the flooding problems. They could be corrected just by leaving them alone. Where if you have a 6-acre zone, or even a 3-acre zone, and part of it's wet, or streams, or just plain wet property, there's room for a house, but there's certainly not room for 85% impervious coverage. To me, it's common sense. It's what Howell is like.
What are the specific comments for or against, Mrs. Smith, just so
For
we can get,
against,
for
okay.
or against, so we can get to some other folks, please.
That's what I'll go for. Would you
Please.
like me to list the permitted uses that I have a problem with and then go on in the SED zones?
Sure.
Okay. I added to those that I mentioned, I have a concern about the wording of manufacturing fabricated metal products.
Okay.
I think that should be a little more restrictive. Manufacturing, printing, and publishing, manufacturing paper and allied products, and manufacturing furniture and fixtures, and lumber and wood. I mean, it's just too basic so that you could basically do anything in an SED zone.
Okay, what else?
I want to address now this, what I feel is not consistent with what was discussed at the planning board. And the R2, the ARE2 to R2, to R1. It's not just Easy Street, it's Lakewood Allenwood Road, it's Newton's Corner Road, it's Herbertsville Road. Now, I didn't go out and look specifically. It's an area I'm familiar with for a lot of years.
Is it safe to say, Mrs. Smith, just for the purposes of getting some other folks, you are against that zone change, as has been outlined in this proposed
Yes, and I'd
ordinance?
like to
Okay.
get a point on record, and
What is that?
that'll probably be it.
Okay, good.
The point is that Mr. Newcomb made reference to only 2 pieces of property, one farmland assessed and the other on the open space inventory. Well, as some of you might remember, I have always objected to that inventory because I feel that it's not accurate, because we're lucky enough in Howell Township to have a lot of small farms that are not either eligible for farmland assessment or people don't bother, but the property is big enough to be open and well taken care of. Small horse farms, small farms, just plain big lots. And in this area, that's what we have. It's not
Okay.
reflected properly by saying, no, there isn't enough open space. I never counted the 1 acre lots. Yes, there are some, but there are a lot more. There's enough to do damage.
All right.
So I
get your
wanted to
comment on
make
that.
that very clear.
Appreciate that.
I have other things, but
I think you've done a very effective job in articulating your concerns. I mean that sincerely.
I hope so. I hope so.
You've
I
done a
mean,
very nice job. We appreciate your comments.
Because I'm not being critical.
We understand.
I just want things done right.
You're entitled to your views, and we appreciate your comments.
Thank you, Ms. Smith.
Thanks for your time, Mrs. Smith. I'm trying to...
Mayor, it's 12:20, what are we going to do?
It's the pleasure of the council.
I think we should carry right this second.
You want to carry it right now?
Carry to the next meeting.
90% of what they're saying ain't sinking.
Can we do that? Carry
I
to the
already
next
told you I'd carry it to January.
Jeez, we gotta get so...
Oh, hold on one sec. Can you just implore me 1 second? I would like us to carry this open meeting to our next meeting, which is December 5th.
December 5th.
Yes.
All right, why don't we hear from this young lady that's in front of us now, and then I'll entertain a motion to carry to December 5th.
Thank you, Mayor.
Okay, the majority of the council agrees, so anyone that's waiting, Lee doesn't stick around for the next few minutes.
Can anybody out there not make it December 5th that must be heard tonight?
I agree.
I would,
Go on.
I would personally would prefer to be heard the next meeting because I have a
Okay.
terrible cold and it's going to be very hard for me to speak.
Okay.
All right, why don't you come back on the 5th then? We'll get to you. Mrs. Weingruber, why don't you come on up since you can't be here on the 5th? Mr. Allen, we're going to get to you. Anyone else here tonight who cannot make it on the 5th? Okay.
Thank you.
Yeah, Mr. Allen's been here since 6:30, 7 o'clock.
Mr. Allen, why don't you come on up? You're going to be next. Good evening, Mrs. Weingruber. Welcome.
Good evening. Suzanne Weingruber, 25 Princeton Drive, almost a 31-year resident. I have never seen a rezoning, this is a rezoning ordinance, that doesn't include a map. I mean, this town's usually pretty thorough, so that you can see in relation what everything is in relation to each other. And this one, not on the one that's out there, not on the one that is here for the public, not on the one that's on the bulletin board.
On Mrs. Weingruber's point, the two maps that we all have were not included in the material that was distributed to the public? I mean, I asked that as a question. I think Mrs. Woolman stepped out of the chambers.
I'll be glad to give you one.
No, we believe you. We're not aware that it wouldn't be in yours because ours has a copy of the map. Right?
Probably not part of the ordinance, because you're going to have to adopt the map at the end of the whole process.
Okay.
And the map is on our website with all the proposed changes.
With all due respect, it's not on the website. The agenda wasn't even on the website, at least as of 11 o'clock today.
The map is on the website, under maps.
You would have to go somewhere else to find this. This ordinance...
Yeah, the ordinance, the agenda did not show up until late in the afternoon.
The agenda did not show up, number one, so if you couldn't get to the agenda unless you came over here to Town Hall, you would not know that this ordinance was on. And if you click on this ordinance, the accompanying maps are not there. The practice in this town, for as long as I've lived here, has been when there's a zoning change, that the map accompanies the ordinance, so that you can see the relationship of what is being changed to the surrounding area. I forget who spoke, I believe it was Mr. Tintillo, talked about transitional zoning. Let me talk about a couple of things. The ARE2 zone, I believe was Mrs. Gillette spoke about around the New Jersey natural gas tanks. That was done in 1989. There was an attempt in late 1990 to change it to R3. And the people in the area signed a protest because they don't want high density either. Mrs. Gillette, I believe that was her name. If I've got it wrong,
Yes, it is.
Excuse me. But Mrs. Gillette is absolutely right. There was a study done that really, some of us pushed to have that zoning around the New Jersey natural gas tanks to ARE6. The compromise was ARE2. To take it down to ARE1, it isn't safe. You're not doing something in the inherent public good. And I'm sure if this ordinance had been on the website, which it wasn't today, that you would have had a lot more people from Ramtown, because you are changing 73 properties, not 30-something, as the planner said. So obviously there's some confusion, even with the people who drew this ordinance up. 73 properties from ARE2 to this new R1 zone. And it probably should be called the rezoning plan for rural Ramtown, because you are rezoning blocks 42, 43, 44, 45, and 46, pretty much in total. On top of which, and those are the ARE2 that are going down to R1. The other things that you are now making ARE1 to R1 includes the now very, very heavily traveled Pinewood Road between Aldrich and Windler Road. We have, I almost got hit by a bus going down there today because the buses now all turn down Georgia Tavern, and they take Windler, and they come down Pinewood. And we are getting, we have so many buses on that road because they're trying to get back to the park and ride, that it really is a problem. So to put any more congestion on here by taking some of these properties and changing them to the R1, because the change, the real change, folks, comes in what is allowed. R1, first of all, let's go back to the first page. It reads, in Section 1, Section 188-69 of the Code of the Township of Howell, entitled Agricultural Rural Estate Zones, is hereby amended as is the balance of Chapter 188 to delete any, keyword, any reference to ARE1 zone and to insert in its place R1. And I'm sure the people up in some of the northern Howell areas, Mackenzie Court, other places that were developed as ARE1, I think, Mr. Walsh, you're probably ARE1 where you live, aren't you? ARE2? ARE2, but ARE1 are going to be very happy to know that somebody could come in, knock a house down in the middle of their street, and put in public recreation if there's 1 acre. Public recreation, including soccer and baseball fields. Public recreation is also miniature golf courses. It is batting cages. Worse yet, I know somebody's going to get upset, but if you have 1 acre now, you can have a club pool on 1 acre as a conditional use. If you think the people were mad about a pool going in ARE6, wait till you have somebody come along and say, hey, I'm buying a property here, I'm knocking down this house, and I want to put in a club pool. You all know that a planning board cannot deny somebody who's in conformance. If they do, it's going to be litigated and they're going to win. Do you really want to allow somebody to put a pool on 1 acre?
Wouldn't they, and I ask this out of ignorance, wouldn't there still have to be parking requirements and other things that would necessary? So just if they would play it out, if they had 1 acre, that wouldn't guarantee them an approval because there would be certain amenities that would have to be required to be set. I mean, I'm asking this to Mr. Newcomb. I mean, wouldn't, if somebody knocked down their house and said, I'm putting a pool in, and I want it to be a public pool club, but they only had 1 acre, how
You're
could that be?
letting them into
No, you would have to meet certain
conditions.
conditions.
Unfortunately, the conditional uses are not spelled out. So this is like putting in, saying we can have a conditional use of a hotel in the HED zone and having no conditions on it. Their conditional uses are not elaborated
Let me just get
here.
back to my question to Mr. Newcomb. If somebody wanted to do that, would the planning board have to approve it if they didn't have parking, if they didn't have?
Right, they would have to meet all those other
So there are other
requirements.
things that,
Right.
so somebody just couldn't knock down her house and say, I got 1 acre, I'm putting a pool in,
Perimeter
everybody come on
buffer,
over.
all those things.
Say again?
Perimeter buffer would be required.
I'm thinking
So-
parking. How can anybody open up a pool club if they didn't have adequate parking?
But there, you're going to be allowed to, it's a conditional use. That should not be a conditional use in an R1 zone. What if somebody buys 3 houses in a row and knocks it
I don't
down?
disagree with you. I said I honestly didn't know the answer. That's why I.
But here you
just-
don't disagree, because if you don't
just-
disagree, it's one of the things that
Just answer the question.
probably should be taken out of there, because you don't even list what the conditions are. It just says club pools. You don't list any conditions. You don't list any conditions? I can put in a club pool. Moreover, permitted uses, permitted principal use is public recreation. I can knock down that house and put in batting cages. I could knock down a house and I could put it, yeah, you could.
I really question that.
Well, you know what? I can see us developing zoning here that's either going to cause commercial operations to be located in what are residential neighborhoods, or we're going to wind up litigating from now until forever. You should not be incorporating commercial operations into a residential zone. The residential zone that you are changing here, there is absolutely no estimate. Mr. Newcomb, do you know the total acreage of ARE2 to R1?
The total acreage?
Total acreage block, of all those blocks that I 42, 43, 44, 45, 46.
The total acreage is, that is basically going to become R1 is 350 acres.
350 acres, folks. How much of that was ARE2?
I don't know. I don't have that figure
Okay.
in front of me.
Quite frankly, if you folks up there can't have all...
It's 1% of the township.
I'm not talking about 1% of the township.
Well, that's-
I want to know how many acres, because if I can now build, I mean, potentially you have another 340 houses, because somebody could come in. I question why we're doing whole...
And only 21 acres of that 350 is vacant.
Doesn't matter. Somebody could knock down a house if they've got 6 acres and build 6 houses. And so that's why you need to know the acreage. It's extremely important.
You know, Mr. Newcomb, on that note, earlier in the evening, you told us that there were 73 lots and most of them are 1 acre.
Right.
So what, are 70 of them 1 acre and 3 of them 100? I mean, there's 350 acres out of 70, that's 5 acres per lot. You told us earlier tonight, most of them were 1 acre.
Right, but there's more than 70 properties. We talked about 70 properties being in ARE2, changed to R1.
Well, we can tell you how many.
Okay, so there's 350 acres total going into R1.
That's, yeah.
There's about 103 acres, 103 lots, Mr. Walsh.
But we only have listed here 60 of them, Mr. Newcomb, right? You showed us the 2 pages earlier?
2 pages, 73 in ARE2, and then you have about another 30, without counting them, maybe 32, 33, that are 1. So you have approximately 100 lots, give or take a few,
Okay.
that comprise 350 acres.
Right, so it's
30,
it's not
you
saying
have
that-
70, you have, another, you have 100 and, a little over 100.
Which comprise 356 acres.
All right.
Okay, and if all those ARE2 lots were only 2 acres, that'd be 140, another 30 lots that are 1 acre, that'd be 170, you're missing about 180 acres here. The potential to build more homes is real. Why? This town has had a long march, starting back in the late 80s, to increase the required acreage to build residential. And I don't think that's a trend you want to reverse, especially around the LNG tanks. I implore
Doesn't
you.
go out that far.
Mr. Newcomb, you weren't here in 1989. I was.
This is the map, ma'am.
Mr. Newcomb, please stop
this
and
is the
listen.
map.
Mr. Newcomb, in
stops
1989,
down
Mr.
that
Newcomb,
far.
this is my time. In 1989, please listen, in 1989, and Mrs. Gillette was correct, all of Easy Street was zoned ARE2. We would have liked to zone it ARE6, but it was zoned ARE2. That was the compromise. And there was lines drawn, there was a study. If I go into my garage and go through my file cabinets, I can probably find the study, although actually probably some of the people who served on the Environmental Commission and everything at that time probably have that study.
It's AR6.
This is Miscavige, Mrs. Coakley, and a few others. And the fact is, that was the reason Mr. Newcomb wasn't here in 1989. I was. I voted on it because it made good sense. We had people actually come in from the various industries, and safety consultants come in and said, this is what you should do. It wasn't just a land use issue. So that was why it's done. I don't care if it's not near the tanks or right next to the tanks. I know where the tanks are. I've lived here almost 31 years. However, it was done as a safety issue, because God forbid anything ever happens in that zone. There's a need to have a buffer, and we didn't want high-density residential. There was a huge fight over what is now Deerwood Park, whether that should have even been rezoned to what it was. So, please think about the residents, not the developers. And if the developers don't like it, well, maybe they can find someplace else to go build.
Mr. Allen, come on up, sir. Good evening, or good morning. You're the last speaker of the night on this. We're going to carry this, Mr. Allen. What comments do you have for us? Welcome.
Ken Allen, Squonkam, Yellowbrook Road. Well, I'm sorry about the late hour.
That's not your fault.
Ed, I'm sorry that I had to put my hand up here, but I may not be here on the 5th, so...
That's fine. Take your time.
Greetings to all of you. I see most of these guys are asleep already, but, and I really don't blame them. It's been a long day. I don't want to go into, I'll keep it as short as I can. I had a lot to say, but I'm going to cut it down because it's late and everybody wants to go home and nobody's really listening anymore anyway. So let's...
We're listening to you, Mr. Allen.
Okay, well, good. Let me just say this in favor of the first part of this. I'm more concerned with the SED zone because as of tonight, I learned I'm in Schedule 6. I think you know me long enough, and I've been around here long enough and to enough meetings that I probably had, if I had an inkling that something was going on that would affect me to any extent, that I probably would have become more involved. However, I was not noticed at any point. It's nice to say we're having a master plan meeting. There's a lot of people in this community who don't know what the hell a master plan is. I can't say I don't know, and maybe I should have attended. However, I did not. I've been very busy, and therefore it's been left to other people to make decisions on my behalf. And quite frankly, I'm not very happy with the decisions that have been made. I'm not at all in favor of pool clubs. I think we went through that. Mr. Walsh pointed out we had quite a row going on last year over a pool club. I don't think there's many people that would want one in their neighborhood. I'm not overly happy about having an active adult community on every corner of Howell Township. I don't know how many times you folks visit active adult communities. My father's 92 and lives in one and has for 20 years. If you really want to take your life in your hands, drive down to Greenbrier Woodlands and drive through, because if you come out in one piece, you're in pretty good shape. I don't mean that to be disrespectful to older people, but I'm telling you, every time I go down there at the entrance of their place, there's glass all over the road. It's a fact of life. And I think we're all gonna get there at some point or another. I'm gonna leave this on a good note anyway, as long as we're going here. We'll get everybody smiling. I think notification is something that really, Mr. Newcomb said something about a super notice, I don't know if that's kind of like Superman. I don't really know what that is. And quite frankly, I wouldn't be very fond of it regardless what it is. I think that if you want to tell me that you're going to change anything in my life, that you should at least put it in writing and send it to me in some form. That was not done. That's probably one of the bigger things on my list, although, I've lived now 28 years in an SED zone. It's not the greatest place to live, but it's really not too bad. I came here because I had a business to run, and I found property that I could afford. At that time, many places in SED zones were chicken coops that were converted into small businesses, and I think they probably went on, some of them, to become very large business. But anyway, if you look at the property, and I won't speak about all the SED zones, I'll speak about my SED zone because I'm down by the Howell High School. I'm on the triangle that runs from Farmingdale up by the high school and then down to 195. It's been changed over the years. It used to extend all the way to the end of 524A or Squonkam Yellowbrook Road. But many years ago, the zoning was changed to up to the point of the, I guess it's the MUA, or was the MUA at that time. It was changed to 2-acre zoning. So the businesses from there down now are in a different situation than we are once you pass the railroad tracks. If you look at that zone, and I did this, and I haven't done it for a while, but I did it quite a number of years ago when there was a zoning problem in the lot next door to mine, and a non-conforming item was going to build on that piece of property, and it ended up not to happen, which I have been very happy for the last 8 years that it did not happen. But what I found at that time was that over 50% of the SED zone in that area is not the Lakewood Industrial Park. It is homes mixed with businesses, and that's where Howell got started. That's where I got started. My home is in the front of my business. I try and keep them separated because I feel that I don't want to live next door to a factory, or I don't want to live next door to my own business. I have to because that's the way it was when I bought it. However, I've maintained at least a 100-foot buffer of trees in between my house and my business, and therefore it makes it a little better for me. But, you know, when we talk SED, I look at this list, it's unbelievable. We've got people living on properties next to things from woodworking to whatever. We're going to put next to these people, next to me, we're going to open up this property to all these uses. I mean, let's look at the list. I mean, if I go down, I don't think offices are too bad. I don't think financial institutions, unless you're going to build the Bank of America there, and then I think that's going to create a little problem. Medical centers are fine unless you're building a hospital. I mean, everybody could use a nice little medical center. Warehousing and distribution. Well, you know, that's a big one. That's a question mark behind that, because what are they distributing and what are they warehousing? Okay, they do fit in the zone. In fact, there will be one going next to me within the next 2 years, I would think. It fits the zoning, and therefore it is really, they deserve their shot at putting their business where they want. Assembly and packing, you know, that, to me, that is so vague. Being in business, you know, what are they assembling and what are they packaging? You know, I mean, I could do nuclear fuel rods. I mean, it really doesn't tell me much what they're going to package and what they're going to assemble. Utility uses, what do we mean by utility uses? We have, you know, we're going to put a coal-burning cogen plant on a couple acres in the middle of Howell. I would rather not see that. Agriculture, forestry, and agricultural services. Not really sure what that is, because most of our forestry and agricultural services are waning in Howell Township, and I think they will continue to disappear over the years. Manufacturing, food, and kindred products. I guess dog food would work there, and it's a kindred product. I know we used to have one in Farmingdale, and you could smell it all the way over on Squonkam Yellowbrook Road when they were cooking it. Manufacturing and textile products. Okay, I suppose that could be a feather burning factory. I don't think I'd want to live next to that either. I won't go on too much more. You've got manufacturing and paper and allied products. Did you ever smell a pulp mill? Would you like to live next to one?
These are all uses that are permitted within your existing ordinance presently.
Not really.
Yes, they are.
I think you better look at it, because my understanding, and when I go back years on this, and I look at light manufacturing, and many times, I said at many meetings, and I heard that the purpose of the SED zone is for, we don't want manufacturing, we don't want Ford to put a plant there, and we don't want this, and we don't want concrete being manufactured, we want light assembly. Okay. When you put manufacturing, that's a whole different category than light assembly. Okay?
Mr. Allen, these are, I can attest to this much. When we talked about this at the planning board meetings, these are all of the existing uses. We didn't add any uses.
Well,
and I could be mistaken.
We eliminated a use.
We actually, what we did, we eliminated
manufacturing of concrete.
We eliminated, I think, the concrete.
Yeah, well, that's true, but that was, I go back to 5, 6, 7 years ago, I sat on a board that looked into, actually, it was an ad hoc committee that looked into installing recreation in SED zones.
Yep, I remember you doing
Okay?
that.
I don't remember all these things being on there.
There are.
Well, I'll tell you what, then they ought to really come off. So I think we really ought to have more work done to look at this thing more carefully, because really you have people living in these SED zones. We just don't have a Lakewood Industrial Park where that's all there is. Howell has never been one that is going to have huge plants and all kinds of stuff. We're going to have some light manufacturing, but for the most part, we're going to have people. Because basically, we're a bedroom community for New York and getting more and more that way each year. I'm sure that the people that are going to move down to Howell don't want to be surrounded by or next to all this manufacturing. So maybe the SED zone should be changed rather than go into all these additional uses and coming up with 2 SED zones now, which I really don't know what that's going to satisfy. That's part of what it is, and that's not all of it. We had people here talk about fish and wildlife being moved and so on and so forth. The one thing that strikes me in my zone, and again, we'll talk about my zone, is you're going to allow 85% asphalt paving on a property that's next to a C1 category stream. Doesn't really make sense, does it? I think that's why we made it a C1 stream to begin with, so that we could save it, because people drink that water. As far as wildlife is concerned, for the past 7 years, I've been working as a state volunteer and cataloging all the wildlife and the herp, meaning turtles and frogs, in the particular zone that I am in and part of Farmingdale. There has been a big decrease in the wildlife that exists in that zone. And it's one of the last places, because of the size and the parcels of land, that these animals can go. Basically, I'll sum it up to say this. I'm happy to hear that there's going to be no vote on this tonight. I think that this should go back for a lot of thought and a lot more discussion. And I think this time, when this discussion comes up, I think that people should be noticed to come in and let everyone know what their side of the story is, because, Mr. Newcomb, I don't think you live in Howell, do you?
No, I did not.
Okay, well, then, I think you ought to be a little more concerned about the people that do live here, and I think that the master plan should reflect the concern for the citizens of Howell. Thank you.
The only thing, and Mr. Allen knows I have great respect for him, and I mean that, but what I would say in deference to Mr. Newcomb, not that he needs to be defended because he gets paid to be here, but I will say this: he's not in an easy spot, and quite frankly, I have to be. I don't disagree with you, but I do have to be candid that this is an individual, right, wrong, or indifferent, who has shown a great deal of concern for our community. He spends an inordinate amount of time in our community, some of which we don't get billed for, and I'm not here to be his cheerleader, because there's times I disagree with him, but I respect him, and I think, in fairness, we're the policymakers. He's not accountable, we are. So he's following the directive that the planning board gave him after countless meetings. He's not putting anything in this report that he was not directed to do so by policymakers. And again, I have great respect for Mr. Allen as a person, and I respect his opinion on a whole variety of issues, and I know he's frustrated, but at the same time, I think in fairness to Mr. Newcomb, he has demonstrated, at least in my judgment, a great deal of concern for our community, and he's really attempting to follow the direction of policymakers. So I just feel compelled to say that, and again, I have great respect for Mr. Allen, and I happen to agree with much of what he said, and I appreciate his concern and his passion on this issue. All right, I think we're going to close I'm actually going to close the public hearing at this point. I'd entertain a motion to carry ordinance. We're going to close it for tonight, and I'd ask that we carry the public hearing, which is 8A1, until the meeting of December the 5th. Mr. Gannon,
What's the proper wording we should use?
What's the...
You don't close it. Motion to carry the hearing. You don't close it.
Okay, all right, so I'm going to reopen it, and I'd ask for a motion to carry the public hearing to the meeting of December 5th.
So moved, Mayor.
We have a motion, we need a second. Motion and a second, any remarks? Hearing none, roll call.
Mr. Shoemaker?
Yes.
Mr. Tabasco?
Yes.
Mr. Walsh?
Yes.
Mayor DeBella?
Yes. All right, if we just do this procedurally, we can be out of here fairly expeditiously. I'm going to begin on 8A2. I'm going to open the public. I'm going to ask a member of the council to simply motion to carry. Ordinance number 0, 0649, introduced and passed on first reading on 10/17/06, and published according to law, is now being taken upon further consideration. Public hearing, affidavit of publication of this ordinance in the Asbury Park Press issue of 10/21/06 is submitted, and is noted that a copy of the ordinance has been posted in the bulletin board of the municipal building, and the copies are available to the general public upon request. Ms. Wallman, would you please read the title of the ordinance?
Yes, I will.
Before you do that, folks, I know we're close to the end. If you wouldn't mind, please, if you need to have a conversation, we just respectfully ask to take it outside. Go ahead, Ms. Woolman.
An ordinance of the Township of Howell, Monmouth County, New Jersey, amending Chapter 188 entitled Land Use in order to provide zoning requirements for age-restricted housing.
Okay, I'm going to, well, I first have to open the meeting to the public for hearing comments for or against final adoption of this ordinance. I'm going to open this to the public. I'd ask a member of the council to please make a motion to carry.
Motion that ordinance number 06-49 be carried to the next meeting, which is December 5th,
Is that the correct way to do this, Mr. Gannon?
The public hearing is to be carried to December 5th.
December 5th, 2006.
Anybody who is interested in this ordinance shall present themselves at that time. There will be no further publication or notice.
Okay, we have a motion. Is there a second?
Second, Mayor.
A motion and a second. Are there any remarks? Hearing none, roll call, please.
Mr. Showmaker?
Yes.
Mr. Tabasco?
C.
Mr. Walsh?
Yes.
Mayor DeBella?
Yes. Call the council's attention to 8A3, land use signs. Give me 1 second. Ordinance number 00650, introduced and passed on first reading on 10/17/06, and published according to law, is now being taken upon further consideration of public hearing. Affidavit of the publication of this ordinance in the Asbury Park Press issue of 10/20/06 is submitted, and is noted that a copy of the ordinance is posted in the bulletin board of the municipal building, and the copies were available to the general public upon request. Ms. Woolman, would you please read the title of the ordinance?
An ordinance of the Township of Howell, Monmouth County, New Jersey, amending Chapter 188 Land Use as it applies to requirements for signs.
Okay, I'm going to open up the meeting to the general public for a hearing. Remarks for or against adoption of this ordinance. I'm going to now ask a member of the council to please make a motion to carry this hearing without additional notification in the meeting of 12/5/06.
So motion that ordinance number 06-50 be carried to the meeting of December 5th, 06. No further notice is necessary. And Tom, add what you need to add.
We have a motion, we need a second.
So moved, Mayor.
We have a second.
That's fine.
Mr. Gannon, is there anything we've missed with respect to comments?
No, Your Honor.
Okay, we have a motion and a second. Are there any additional remarks? Hearing none, roll call, please.
Mr. Showmaker?
Yes.
Mr. Tabasco?
Oui.
Mr. Walsh?
Yes.
Mayor DeBella?
Yes. We are going to act on 00652, amending the ordinance 00620, Basin Forest Ridge Homeowners Association, which is as follows. 8A4. Ordinance 00652, introduced and passed on first reading on 10/17/06, and published according to law, is now being taken upon further consideration in the public hearing. Affidavit of the publication of this ordinance in the Asbury Park Press issue of 10/20/06 is submitted, and it's noted that a copy of the ordinance has been posted in the bulletin board of municipal building, and the copies are available to the general public upon request. Ms. Woolman, would you please read the title?
An ordinance of the Township of Howell, Monmouth County, New Jersey, amending Ordinance 0-06-20, titled, An Ordinance of the Township of Howell, Monmouth County, New Jersey, accepting the drainage and retention basins located on Block 1.23, Lot 11, and Block 1.19, Lot 8, as dedicated by the Forest Ridge Homeowners Association.
I'm going to open the meeting to the general public for comments for or against final adoption of this ordinance. Anyone who'd like to be heard on this particular ordinance, please come forward. Anyone who'd like to be heard? Let the record reflect no one is asked to be acknowledged or heard on this particular ordinance. I'm going to close the public portion. I'd ask for a motion from the council.
Motion that ordinance number 06-52 be finally passed and adopted, and that notice of its passing and adoption be published in the December 1st, 06 issue of the Asbury Park Press by reference to its title only.
Okay, we have a motion. We need a second.
Second.
Motion and a second. Are there any remarks? Hearing none, roll call, please.
Mr. Showmaker?
Yes.
Mr. Tabasco?
Aye.
Mr. Walsh?
Yes.
Mayor DeBella?
Yes. 8A5, 00653, ordinance number that is, introduced and passed on first reading on 10/17 and published according to law, is now being taken upon further consideration in a public hearing. Affidavit of the publication of this ordinance in the Asbury Park Press issue of 10/20/06 is submitted, and it is noted that a copy of the ordinance has been posted on the bulletin board of the municipal building, Copies were available to the general public upon request. Ms. Woolman, would you please read the title of the ordinance?
Yes, I will.
Yeah, that's fine, so we're just thinking about.
An ordinance to amend an ordinance entitled, "An Ordinance Fixing Salary and Compensation of Certain Officers, Positions, and Employees in the Township of Howell, County of Monmouth, New Jersey for the year 2006, and thereafter known by its short name as Howell Township Salary Ordinance."
Okay, I'm going to open the meeting to the public comments for or against final adoption of this ordinance. Anyone who'd like to be heard, please come forward. Anyone who would like to be heard, please come forward. Let the record reflect that no one is asked to be acknowledged. I'm going to close the public hearing. Councilmember
Motion
Booth.
that ordinance number 06-53 be finally passed and adopted, and that notice of its passage and adoption be published in the December 1st, 06 issue of the Asbury Park Press by reference to its title only. Need a
Okay,
second.
we have a motion, we need a second, please.
Second.
Motion and a second, are there any remarks? Hearing none, roll call, please.
Mrs. Showmaker?
Yes.
Mr. Tabasco?
Yes.
Mr. Walsh?
Yes.
Mayor DeBella?
Yes, we have one ordinance, actually, we have several that need to be introduced.
Mayor, if you prefer, you can, by motion, move these for introduction on the 5th, or you can introduce them now.
Penny, could they be published in time for the public hearing?
Yeah, the only thing I question is the bond ordinance. Is that pulled from the year?
Yeah, that's pulled for the...
Why don't we just introduce them? It takes just a few minutes to introduce. Is any objection to that? And it's already
2 minutes to one, what's the
It's already 1
difference?
o'clock, I gotta be at 4:30.
Okay.
All right, so call the council's attention to introduction of ordinances. This is 9A1. We're amending Chapter 265, Snow and Ice, to include Newton's Corner Road as a non-parking thoroughfare. I ask the member of the council to proceed.
All right, just there. Motion to introduce ordinance 06-54 on first reading by title and to order the same to be published in full in the December 106 issue of the Asbury Park Press, together with notice of its introduction and passage on first reading by title, and that it will be further considered for final passage after public hearing and a meeting of the Township Council to be held on December 19th, 06 at 8 p.m. prevailing time in the municipal building. Need a second.
We need a second. A motion and a second. Ms. Woolman?
An ordinance of the Township of Howell, Monmouth County, New Jersey, amending Chapter 265, Snow and Ice, Article 1, to include Newton's Corner Road as a no parking thoroughfare during certain snow events.
Okay, roll call, please.
Mr. Showmaker?
Yes.
Mr. Tabasco?
Yes.
Mr. Walsh?
Yes.
Mayor DeBella?
Yes. Council's attention to 9A2, amending 0066 vacation, drainage, and conservation easements, Route 33. Route 33.
Motion to introduce ordinance number 06-55 on first reading by title, and to order the same to be published in full in the December 106 issue of the Asbury Park Press, together with notice of its introduction and passage on first reading by title, and that it will be further considered for final passage after public hearing and meeting of the Township Council to be held on December 19th, 06 at 8 p.m. prevailing time in the municipal building.
We have a motion, we need a second.
Second.
Ms. Woolman?
An ordinance of the Township of Howell, Monmouth County, New Jersey, amending ordinance number 0-06-6, entitled, "An ordinance of the Township of Howell, Monmouth County, New Jersey, vacating all the right, title, and interest in and to the public to an existing drainage and conservation easement located on property known as Block 175, Lot 4.02, as a result of the redevelopment of said property, order to correct the property description to read Block 175, Lot 40.02.
Roll call, please.
Mrs. Showmaker?
Yes.
Mr. Tabasco?
Da.
Mr. Walsh?
Yes.
Mayor DeBella?
Yes. Call the council's attention, 9A3, 00656, amending ordinance 0067 as it pertains to third-party payment plan for EMS.
Motion to introduce ordinance number 06-56 on first reading by title and to order the same to be published in full in the December 106 issue of the Asbury Park Press, together with notice of its introduction and passes on first reading by title, and that will be further considered for a final passage after public hearing and a meeting of the Township Council to be held on December 19, 06 at 8 p.m. prevailing time in the municipal building.
With a motion, we need a second.
Second.
Ms. Woolman?
An ordinance of the Township of Howell, Monmouth County, New Jersey, amending ordinance number 0-06-7, entitled, "An Ordinance of the Township of Howell, Monmouth County, New Jersey, establishing and implementing a third-party payment plan for emergency medical services."
Roll call, please.
Mrs. Showmaker?
Yes.
Mr. Tabasco?
Yes.
Mr. Walsh?
Yes.
Mayor DeBella?
Yes. 984-00657, amending the bond ordinance 05...
I think that's,
That was pulled, Mayor.
I apologize, that's been withdrawn. 985, amending Chapter 306 entitled Towing. Member of the council.
Motion to introduce ordinance number 06-58 on first reading by title and to order the same to be published in full in the December 106 issue of the Asbury Park Press, together with notice of its introduction and passage on first reading by title, and that it will be further considered for final passage at the public hearing and a meeting of the Township Council to be held on December 1906 at 8 p.m. prevailing time in the municipal building.
We have a motion, we need a second.
Second.
We have a motion and a second. Ms. Woolman, would you read the title?
an ordinance of the Township of Howell, Monmouth County, New Jersey, amending Chapter 306 entitled Towing of the Code of the Township of Howell in order to amend, supplement, and revise said regulations.
We have a motion, we have a second. There is a member of the public that's acknowledging they'd like to be heard on this. We have a public, this is merely an introduction of this.
I realize.
We're going to take public comment on this on December the 19th. So tonight is a parliamentary process merely to introduce this so that it may be advertised to the public.
It's going to be acted on the 19th.
It potentially can be acted on the 19th. It may be voted on, it may be voted down, it may be tabled. On the 19th is when we're going to be soliciting input from the public with comments for or against this particular item. And at that time, we'll have a formal public hearing, and you'll be absolutely entitled to give us any commentary you may like as it relates to that particular issue. But from a parliamentary perspective, this is merely an instrument to open the discussion, if you will, to advertise this. This is not the evening when we take a comment on this particular item. So on December 19th, you and other members of the public will be invited to give us as much testimony as you may like about this particular issue. All right, so we have a motion, we have a second. Roll call, please.
Mr. Showmaker? Yes. Mr. Tabasco?
Yes.
Mr. Walsh?
Yes.
Mary Tabella?
Yes, motion to adjourn. All those in favor?
Second.
Aye.